Commercial Law. Although the ECS is Negotiable Instruments Law. You're smiling. The ECS subject is Negotiable Instruments Law. It's very simple. It has a pattern which has to be followed, and when you follow it, it's no problem at all. So my assignment is transportation laws. Okay. Yes, I will discuss these topics, but in accordance with my own arrangement. This is so mechanical, and the arrangement is not really that logical. Tama-tama timing nun eh. Okay, so I thought it was a bass drum. Okay, so we start with Article 1732 of the Civil Code. And we talk about common carriers for a moment before maybe next meeting we go to maritime commerce and the Warsaw Convention, etc., etc. Now, common carriers, 1732 of your Civil Code. You see the definition. A common carrier does not refer to an airplane. A common carrier does not refer to a vessel. A common carrier does not refer to a truck. It does not refer to a bus. Common carriers are persons. Common carriers are corporations. Wait, I don't think the camera is working. Can you see me there? Oh God, where is the boy? He put me on remote control. Oh. Okay, but when I stand up, the other children in the other rooms will not be able to see me. I don't know, I need to stand up. That's alright. Common carriers are persons, okay? Common carriers are corporations. Common carriers are firms. They're associations. And as persons, corporations, firms, or associations, they are engaged in business. Yeah, think about that. They are engaged in business. And what business? The business of carrying or transporting goods or persons or both. By what mode? By land, water, or air. And do they transport persons and goods or both for free? No, for a compensation. And to whom do they offer their services? To the public. And if you are going to be asked the test of what a common carrier is, to avoid confusion, because they have been described in various ways in jurisprudence, and if you are taking the bar exams, the shortcut, the sure way to impress the examiner is for you simply to use 1732. But do it in an enumeration form, not a definition form. What is the true test of a common carrier? Then talk about the elements of a common carrier. That's why when we discuss these things at the UP Law Center, we always talk about the codal provisions. And that is what we suggest to the examiner as answers, because the safest answer would be the codal provisions, irrespective of what certain decisions say, because they're not very consistent as to what the test is. And so I'm telling you, in case of doubt, use the codal provisions, you will never go wrong. Now, the most famous case on the nature of a common carrier is that case that was decided on December 22, 1988. Let me apologize. I will be talking very slowly right now. I'm trying to conserve my voice, okay? I will talk in a very slow tempo. You know, that case decided on December 22, 1988, and so could be 168 SPRA. Yes, 168 SPRA. The page could be 612. But the date is December 22, 1988. That famous case of the Guzman versus Court of Appeals. And that has been the case that had been consistently used in the bar examinations. Now, the Guzman is a very simple case. It talks about a certain Mr. Sendanya, a businessman from Dagupan, Pangasinan. And his regular business was to sell scrap metals, bottles, and all forms of junk. Maybe you recall now the case. Do you recall the case? Yes. He would sell all sorts of junk. And he would fill up his 2 Isuzu trucks. And when his 2 big Isuzu trucks were filled up, he would come to Manila and sell them. And that was his main and regular business, selling scrap metals and other forms of junk. But he had quite a problem because when everything has been sold, his 2 big Isuzu trucks would travel back to Dagupan empty. So sayang ang space. So now what he did, he knew that there were businessmen from Dagupan who would come to Manila, to Divisoria, to Baclaran, and buy their goods. And then he enticed them not to load their goods in the normal common carriers like Victory Liner, etc., Dagupan Lines, 5-star. And they said, dito na kayo sa akin, you load your goods in my 2 Isuzu trucks at a cheaper price. And so he would offer those businessmen the use of his 2 Isuzu trucks. Then one day, this guy, De Guzman, came to him and said, I have 750 boxes of Liberty-filled milk. Can I load them with you? He said, yes. But 1 truck is almost loaded. So he said, you put 100 cartons of Liberty milk in 1 truck and the 650 in another truck. But lo and behold, one of the trucks was hijacked on the way to Dagupan. It was not able to reach its destination. So the other guy, the businessman, lost hundreds of cartons of Liberty-filled milk. Do you remember that milk? I remember that. That belonged to my generation. Liberty, Dairy Gold, Alpine, that was my generation. I do not belong to the en famille generation. Maybe you do. Okay? And so there was an issue. The issue was Gregorio Sendanya, as operator of the 2 Isuzu trucks, did not observe the extraordinary diligence required of a common carrier. But Gregorio Sendanya said, I am not a common carrier. I am a private carrier. Now what was his reasons? Or what were his reasons? He said, my regular business is selling bottles, scrap metal, and junk. This backhauling of goods from Manila to Dagupan and my act of inviting businessmen to load their goods in my truck is only episodic. It's not regular. It's only a sideline. You know what the Supreme Court said to his argument? Look at the definition of 1732. It only says you are engaged in the business. It did not say you must be engaged in a regular business. Hence, if you are engaged in business, even if it is only a sideline, even if it is only episodic, Even if it is only from time to time and not regular, you are a common carrier. Because regularity is not part of the definition of 1732. It only says engage in business. Do you charge them a fee? Yes. What does the definition say? You charge them a fee for a compensation. Then he said, I have no fixed schedule for my trips. The Supreme Court said, does the definition say you should have a fixed schedule to be a common carrier? The Supreme Court said, no. You do not see the requirement of having a fixed schedule in the definition? You don't. You know what he said? How could I be a common carrier? I have no certificate of public convenience. The Supreme Court said, holy smoke, there is no such thing as certificate of public convenience required in the definition. Then he said, I am not offering my services to the general public. I am only offering my services to a limited segment of the public, the specific businessmen in Dagupan, Pangasinan. Do you find the word is specific members of the public in the definition, said the Supreme Court? That limited segment is still a member of the public. They are still members of the public. It did not say to the general public and to everyone in the public. They are members of the public. You are a common carrier. You know, although he was absolved of liability later on because it was shown that the hijacking was attended by grave, irresistible force, violence, or threat, but that is the subject of another matter later on. But our issue now is, was he considered a common carrier? The answer is yes. That's why suppose you are going to be given a problem. Are tricycle operators which you see in Mendiola and Ligarda considered as common carriers? The answer is yes. Are the operators of those pajaks, etc., those tricycles without motors, also considered common carriers? They are, under the definition. Are the kalesas common carriers? Yes, you need no motors to be a common carrier. Are the rig operators, kalesa nga pala yun, rig operators, are they common carriers? They are. But incidentally, tricycle operators, pajak operators, kalesa operators have not yet been the topics of the bar exam. That should be. Now, this case of the Guzman was decided by the Supreme Court on December 22, 1988. And the bar exams at that time was November 1988. I remember it. I was the head of the bar operations in 1988 bar. And after 2 months, I left the country already. It was not asked in 1990. I verified it. It was not asked. It was not asked in 1989 bar. There was no such question. It was not asked in 1990 bar, but the Guzman was asked for the first time in 1991. I don't know if someone here has a bar exams in commercial law. Do you have one? Wow, he's always ready. Yes, okay. Could you open it to 1991 bar exams? That would be number 16, okay? That's number 16. That's what I remember. Now, you know, commercial law is a subject where famous cases are normally found in the bar. Of all the subjects, remedial law, the questions are hypothetical. Very seldom are actual cases asked, but in commercial law, they're asked. Like the Guzman. For the first time in 1991, number 16. The Guzman was used by the examiner, but instead of Dagupan, it became Cebu. Instead of Gregorio Sendanya, it became Alejandro Camaling. Instead of the Guzman, it became Pedro Rabor. Instead of Liberty Filled Milk, it became Sardines. Okay? But the actual facts were the same. Could you open it to 1991, number 16? Okay, thank you very much. I just want you to see how an examiner could use an actual case in commercial law. I hope you won't mind my reading this. And you are going to answer this. This was 5 points. Listen to this. Alejandro Camaling of Alegria, Cebu is engaged in buying copra, charcoal, and firewood. See, it's no longer scrap metals. And in reselling them in Cebu City. See that? It's no longer Dagupan and Manila, but Cebu. He uses 2 big Isuzu trucks for the purpose. See that? The Isuzu trucks were borrowed by the bar examiner. He has no originality. However, he has no certificate of public convenience. Wow! Shades of the Guzman. And on the return trips, he loads his trucks with various merchandise of other merchants in Alegria and the neighboring municipalities of Badian and Binatilan. Those of you from Cebu know these places. I know these places. He charges them freight rates much lower than the regular rates. Now listen to this. Another shade of the Guzman. In one of the return trips which left Cebu City at 8:30 p.m., one cargo truck was loaded with several boxes of sardines. See? At least he was original here instead of using milk. While passing the zigzag road, blah blah blah, the truck was hijacked by 3 armed men, the same as the Guzman, who took all boxes of sardines. Okay, it's very long. The issue here is, would you consider Alejandro Camaling as a common carrier? Listen to this. This is what we just discussed. If I were the judge, I would hold Alejandro as having engaged as a common carrier. A person who offers his services to carry passengers or goods for a fee is a common carrier regardless of whether he has a certificate of public convenience or not, or whether his main business is incidental to such business, whether he has scheduled or unscheduled services, or whether he offers it to the general public or to a limited few. 1991, number 16, bar exams. Almost a carbon copy of the Guzman. Now, was it asked in 1992? I don't remember it. Was it asked in 1993? I don't remember it. Was it asked in 1994? I don't remember it. Was it asked in 1995? I don't remember it. Was it asked in 1996? I remember. Should be 1996, number 14. But it was not as long as the Guzman. But the essence was the same, and the Guzman could make a sudden comeback because you have essay exams. Okay, let me try to check. Huwag kayong mainip. I'm checking this. You know, there are many cases in transportation law. Let's just check. 1994, 211. So it should be number 14. So I'm on the wrong page. I couldn't find bar 1996. Some of this. Could you find it for me, Iyo? Anyway, you will be my assistant, okay? 1996, number 14. That could be it. Okay. This was about AM tracking. Okay? AM tracking had no certificate of public convenience. AM tracking had no definite or scheduled trips. And the same was the issue. And this driver visited his girlfriend in Bulacan, only to know that those that were loaded in his truck were already taken by thieves. Okay, let's have this. AM Trucking, a small company, operates 2 trucks to hire on selective basis. At least this is a shade of the Guzman, 2 trucks. It caters to only a few customers, and its trucks do not make regular or scheduled trips. It does not even have a certificate of public convenience. On one occasion, medyo pabling itong driver eh. Playboy. On one occasion, Reynaldo contracted AM to transport for a fee 100 sacks of rice from Manila to Tarlac. However, AM failed to deliver the cargo because its truck was hijacked when the driver stopped in Bulacan to visit his girlfriend. May Reynaldo hold AM liable as a common carrier? The answer is the same as in the Guzman. You don't have to have regular trips. You don't need to have a certificate of public convenience in order to become a common carrier. So when you answer a problem like this, just look at the definition. That is your life. Oh, there could be many possibilities here in common carriers. In fact, the concept of a common carrier is the number one bit in transportation law. Aside from the doctrine of limited liability and collision of vessels. Now, so that was 1996. Was the Guzman asked in 1997? No. Was the Guzman asked in 1998? No. Was the Guzman asked in 1999? No. Was it asked in 2000? Yes. It was asked. This time it was about Tamaraw FX. 2000, number 12, maybe. I am just guessing, but it could be the FX Tamaraw. Maybe I should put a chair beside me. Or you are going to act as a witness sworn to look for the right page. Yes, okay, you listen to this. This guy is a lawyer. See? Moonlighting as an FX Tamaraw driver. And this is not good for lawyers. X has a Tamaraw FX among other cars. Well, that's a saving grace. Marami naman pala siyang cars. Every other day during the work week, he goes to his office in Quezon City using his Tamaraw FX and picks up friends as passengers at designated points along the way. His passengers pay him a flat fee for the ride, usually 20 pesos per person. This used to be the price before. Yeah. One way. Although a lawyer, although a lawyer, he never bothered to obtain a license to engage in this type of income-generating activity. He believes that he is not a common carrier within the purview of the law. Do you agree with him? No. I do not agree with X at the UP Law Center. This is 2000. Oh, I was not in the Philippines at this time. A common carrier holds himself out to the public, blah, blah, blah. It's also the same as the Guzman. Even if it is only a sideline activity, it is still an act engaging as a common carrier. This was the last time it was asked this way. Although in 2005, there was a suggested topic, the same as this, but it wasn't asked. It was like this. Mr. X owns a fleet of helicopters. This was a suggested bar exam question, but it was not asked in 2005. He has a fleet of helicopters. Every Sunday, he would offer 2 of his helicopters to parachute enthusiasts, to parachutists. And they would be brought 15,000 feet above sea level, and there they would jump. Each of them would pay 2,000 pesos per jump. But he only does it during Saturdays and Sundays. The question there suggested is the owner of those 2 helicopters engaged in the business as a common carrier? How would you decide with that? The answer is yes. Even if it is not his regular business, you would use the definition, he was acting as a common carrier. Did he offer his services to a segment of the public? Yes. Did he ferry them? Yes. Did they pay? Yes. Common carrier. You're going to use 1732. Okay. Let's talk about certain cases. I'll borrow this later. You know, there was this case of Bascos versus Court of Appeals. It's in 221 Scra. You don't have to copy, by the way. Listen to the doctrine. He owned several trucks. Sometimes, some of his trucks are being leased to persons, and he supplies the drivers also to ferry goods from one place to another. An issue that reached the Supreme Court was very simple, like the Guzman. In fact, the Guzman was used in this case. He said, I only lease this to a particular sector of the public. I don't offer this to everybody, but only to owner of goods. I don't offer it to the public in general, but only to the owner of goods. And I lease them not on a regular basis, only when I like. So again, it is episodic, it is only ancillary, it's only a sideline, because I have my regular customers for my trucking business. And when I lease it to someone, it's only on a selective basis. The question is it acting as a common carrier? The answer is yes. That was what the Supreme Court said. Whether it is ancillary or regular is not very important. The word ancillary or irregular or regular, they're not found in the definition of common carriers. When you were students, probably, you came across the case of Fabre versus Court of Appeals. This referred to spouses who owned a minibus. Their regular business was to carry and ferry and transport children from school to their home and from home to their school. And their customers were the students of St. Scholastica's College. But sometimes they lease their vehicle for the use of certain individuals. And one day, a group of Catholic youth workers hired their minibus to loan you. Then there was an accident, and the issue also was, is it acting as a common carrier? The same answer was given by the Supreme Court. The defense was the same. Our regular business is minibus, transporting children from school to their homes and from their homes to their school. This is only episodic. This is only ancillary. This is only a sideline. The Supreme Court also said, you are a common carrier. Now, did you study Asia Literature versus Court of Appeals? Did you come across it? Never mind. The same issues. These are the common issues. Asia Literature in 409 Scra, that's 409 Scra, had also several barges. It actually has regular customers. Then one day, one of the ships that anchored at South Harbor used two of their barges because of a defect in the hull of the barge. One of them capsized and the goods were lost. And the issue also was Asia Literature a common carrier under that transaction? And the argument was the same. We don't rent this to that ship. Always, we have regular ships as customers. But the Supreme Court said, you said it's only ancillary? No, you're still acting as a common carrier. In fact, you have several barges for it. Common carrier. But one case which was not yet asked in the bar exams, because the cases, the principles in the Guzman, the principles of Bascos, the principles of Fabre, the principle in Asia Literature, they were asked already in the bar examination questions I gave you a few minutes ago. But one has not been asked yet. Crisostomo versus Court of Appeals. And this is something which you should see even in your books. You have this. It's a standard case, Crisostomo. Whoever author you go to, you have Crisostomo versus Court of Appeals. This is also 409 scrap. This was about a lady lawyer whose passion was to travel. Then one day in the newspaper, she saw advertised a trip to Europe. And the name of the trip was Jewels of Europe. The cost was almost 75,000 pesos. That was 1991. Okay. And so, she went to Caravan Travels and Tours to ask Caravan Travels and Tours to help her facilitate her travel, her ticketing, and her booking with transportation carriers. And lo and behold, she was given the ticket. Her accommodations were prepared, and she was set to go to Europe. She went to the airport on June 15, 1991, only to find out that her plane left the day before, June 14, 1991. Look, the tickets were given to her 2 days before the travel. She did not bother to read because she said she had the impression it was June 15, 1991. And so to appease her heart, Caravan Travel said, doon ka na lang pumunta sa isang tour. Ang pangalan ng tour ay British Pageant. Pero hindi talaga pageant yun. Yun lang ang pangalan ng tour. British Pageant. So, tinanggap niya. Para lang siya makatravel dahil sayang. Pero, ang cost ng British Pageant at saka Jewels of Europe, magkaiba. Mas mura yung British Pageant. Eh, nakabayad na siya ng almost 75,000. Pagbalik niya, sinisingil ang difference. She was asking for a refund. Hindi na refund. And her argument was very simple. You had the duty to observe extraordinary diligence. That means your duty also includes informing me about the details of my trip, even if I did not read them. Because your duty is extraordinary diligence. Because you are a common carrier, she said. The Supreme Court said, Caravan Travels only facilitated the purchase of tickets, the booking of the travel. There was no promise to transport you. The one that would transport you would be the airlines, not Caravan Travels. The duty only was to arrange and facilitate your travel, including your accommodation. A travel agency, under those circumstances, is not a common carrier. That's the doctrine in Crisostomo versus CA of 409 scrap. Okay? But listen to this. There could be a twist here. If the package store of the travel agency, for instance, includes in its package transportation from one place to another, and the transportation is an integral part of the package. Get my point? Integral part, nakasama sa kanilang trabaho na i-transport ka. The travel agency could be construed to be a common carrier. Where its trabaho is not only to facilitate the transportation, but sila mismo ang magta-transport sa'yo. Get my point? Magiging common carrier yun kung sila mismo ang magta-transport sa'yo. You know, there is this case similar to that, although the case did not involve really a strict travel agency, but a resort operator. This was a later case already. It was already in 622 scrap. Let me try to think about the case. Cruise versus Sun Holidays. Yes, Cruise versus Sun Holidays. Now, Sun Holidays Incorporated actually operated beach resorts. And to entice its customers, it would transport its customers from one pier to another until they reach the beach resort. It was actually Sun Holidays that transported them through their designated boats. In one of the strips, one boat capsized and several passengers died. The issue was Sun Holidays acting as a common carrier? According to the Supreme Court, an integral part of their promotions was to transport on their own customers to the beach resorts. It was an integral part of their promotions, transportation on their own. Hence, they were acting as a common carrier. Did you study these cases while you were in your undergrad? I think you did. This was not yet asked in the bar. Another matter that was not yet asked in the bar exams is whether or not a customs broker could be considered a common carrier. And the leading case, there are many cases on this, there are 17 cases. And the leading cases is Calvo versus UCPB, 379. You know, the customs broker said, my job, regular job, is to facilitate the release of cargo from the customs office. My job is not to transport. I do not transport goods, but the Supreme Court found out in the facts of the case that after they facilitate the release of their goods, an integral part of their business was to transport the goods released from customs to the warehouses of their customers. Since it was an integral part of their business, it was acting as a common carrier. So a customs broker transporting goods as an integral part of its business is considered as a common carrier. I am thinking of another case which was not yet asked. Yes, in Mindanao, the Mindanao Terminals case in 587 scrap has not been asked. Would you consider a stevedoring company a common carrier? Think about the facts of the case, okay? Look at the facts of the case. If you lose that case of Mindanao Terminals of 587 scrap, the job, the regular job of the stevedoring company, in fact, its only job was to unload and load cargo and store them in the nearest place without transporting them. It's not acting as a common carrier. Loading and unloading goods, you do not act as a common carrier. As long as there is no transportation of goods from one place to another for a fee. So, pagdating ng barko, i-unload, ilalagay sa sulok, yan, i-store. Storing and unloading is not acting as a common carrier. It's not really a very old case because it's still 587 scrap, Mindanao Terminals. But one of the cases we've been waiting for to be asked in the bar examinations is a beautiful case. It has not been asked in the bar exams. I don't know what these bar examiners are doing with this case. First, Philippine Industrial Corporation versus Court of Appeals. 300 scrap. $300 scrap 661. Yes. Okay. First Philippine Industrial Corporation is engaged regularly in the business of transporting oil and oil products, not through trucks, but through pipelines. Then it opened a pipeline business in Batangas. And it had pipes. Look at this. See, it's staggering. It had pipes running from Batangas going to Pandacan. Sino nasa loob ng pipes? Hindi tao. Oil. Crude oil. You see how beautiful this case is? And it need a mayor's permit to operate. But the city of Batangas said, we cannot give you a permit unless you pay the following local taxes. Under the law invoked by the city of Batangas, transportation companies and common carriers are exempted from the tax to ease the burden of consumers. Baka ipasa sa kanila ang cost ng tax ng common carrier. Kaya exempt ang mga common carriers doon. Alam mo ang sabi ng First in Philippine Industrial Corporation? Dapat exempt kami sa tax dahil kami ay common carriers. Nagkaroon ng kaso hanggang makarating sa hukuman. Ang sabi ng City of Batangas, paano kayo maging common carriers? Mga pipes kayo eh. Pipeline kayo. Wala kayong motor. Wala kayong trucks. Ang sabi ng First Philippine Industrial Corporation, but we transport goods. Di ba yung oil? Goods. Di ba pag pumasok sa pipeline, transporting yun? Nagbayad na lang sila ng tax under protest para lang mabigyan ng permit. So, talo sila mula sa ibaba hanggang sa CA. Pagdating sa Supreme Court, sabi ng Supreme Court, nung una, okay? Nung una, hindi kayo common carriers. Nag-file ng motion for reconsideration. Sabi ng Supreme Court ay, common carriers pala kayo. Kasi kung titingnan natin ang definition ng Article 1732, do you engage in the business of transporting goods? Yes. Are those goods? They are goods. You do not need motors. Tapos bumalik sila sa Petroleum Act. Oo nga, common carriers ang turing. Kailangan munang magkaroon ng motion for reconsideration para buksan ang mata ng Korte Suprema at makilalang ang First Philippine Industrial Corporation ay common carriers. Tingnan nyo yan. Kung titingnan nyo ang argument ng City of Batangas based on common sense, hindi naman kayo motor. Wala kayong motor. Walang motor sa loob ng pipe. Walang gulong. Hindi naman aeroplano, walang pakpak. Paano kayo maging common carrier? Dahil ang nasa isip ng City of Batangas ay ang normal na meaning ng mga equipment ng common carriers. Eh ito, pipeline. So, bigla kong naisip nung una kong mabasa ang kasong ito ay, this was a 1999 case. Pwede nga palang mag-transport ng tao through pipelines. No? Sabay ka doon sa oil. Yan ang mabilis yun, madulas yun, kaya ang bilis-bilis. See, this has not yet been asked in the bar exams, mind you. I don't remember, I may be wrong, but I don't remember this question having been asked. It's high time it should be in the bar. Because this is an unusual case. Pipeline operators. See? Kaya para ma-ease ang traffic congestion, pipelines. Ayun, hanging sa itaas ng LRT, MRT, pipelines. Pagpo ganun. Para kang nasa mga resorts na merong slides. Yan, slide ka lang. Oh. Galing ka sa Quezon City, slide ka papuntang Recto. Ang landing mo dyan sa labas ng San Sebastian. O, biro mo yan. Gas-gas ang puwit mo pagdating mo. So, common carrier yun. Okay, here comes Republic Act 9136. The Electric Power Industry Reform Act. You have heard this word, APIRA, okay? Republic Act 9136. And Section 22 of that law is very revealing. It's a beautiful one. And it says, the distribution of electricity to end users is a regulated common carrier and therefore requires a national franchise. See, the distribution of electricity to end users is a regulated common carrier and requires a national franchise. Meralco, therefore, is a common carrier, because Meralco is engaged in the distribution of electricity to end users. You see that? Gusto mo sumakay sa kuryente. Okay? Look at that. See, look at that definition of a common carrier. It transports electricity to end users. It is called a regulated common carrier. Republic Act 9136 and Section 22 of that law. So if you hear the word EPIRA, what is EPIRA? Electric Power Industry Reform Act. See, Electric Power Industry Reform Act. Now let me look at the syllabus, and that's alright. I'll use that later. Okay. The next topic we are going to have, and I hope we finish this in half an hour before we break, is, or are some topics about the distinction between a common carrier and a private carrier. And let me think when this was asked. 10 years ago, it was asked. In 2002, number 8, distinctions of a common carrier between a common and a private carrier. It could be number 1. There were 2 questions there. He is looking for it now. Never mind, I'll just stop. But could you check it? 2002, number 8. I may be wrong. See? But I remember there was a question there. My instinct tells me so. Is it? Oh yeah, never mind, it is. He confirmed it. I was just confirming it on my own. Sometimes I'm playing with my memory. Okay. Now give me one distinction between a common carrier and a private carrier. This could be an essay question. Okay? Very simple. A common carrier offers its services to the public. A private carrier does not offer its services to the public. Now, the diligence required of a common carrier is fixed in the law. It's extraordinary diligence. What is the diligence required of a private carrier? Come on, babies. Civil law. No. Do not answer ordinary diligence or good father of a family immediately. You know why? That's not the rule. Diligence of a good father is not the rule. Look, let me try to recall a civil code provision, okay? Give me a few seconds. My drive C is still loading. Yes, 1173. Let's talk about the second paragraph. It says that if the law or the contract does not provide the diligence required, only then will you follow that of a good father of a family. So you're going to ask, what does the law say? So there is no law, okay? Because the law is on common carriers. What is the stipulation? If there is no law, there is no stipulation, then saka pa lang papasok ang diligence of a good father. See? Huwag yung biglang ko ako examiner, mamaliin ko kayo agad. So, anong diligence ng private carrier? It depends upon the applicable or the stipulations. In their absence, then diligence of a good father. 1173, that's paragraph 2. In fact, that same diligence is also the one mentioned in another article of the Civil Code, 10 articles earlier. Even an obligation to give. You know what does it say? You know what it says? Every person obliged to give something is also obliged to take care of the thing with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. So you look at the stipulations, look at the law. In their absence, go to diligence of a good father. See? You understand me? Oh, that's purely codal. Could you give me 1173 of your civil code? It's the second paragraph. Saibel, can I borrow it? Where is Ria? Okay. Now look at 1173. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. Only if there is no law, only if there is no contract, only if there is no stipulation. These are basic things in civil law. Is there any other difference? Yes. There is no presumption of negligence in a private career. But there is a presumption of negligence in a common carrier situation. The presumptions of negligence in a common carrier situation, we will take up in a little bit, but let me mention the articles. They are found with respect to goods in 1735 and 1756 with respect to passengers. Okay, let me ask you, okay? Let's talk about your stock knowledge. Let's talk about a private carrier situation. Private carrier. Okay? The private carrier lists its airplane to me. It does not offer its services to the public. Nagkataon lang, kilala ko siya. Pinarentahan na lang sa akin. Wala siyang business na ganun. Pinarentahan lang sa akin. Nakalagay sa stipulation that the carrier or its owner shall not be responsible for the acts or omissions of its employees. Next stipulation, that the carrier shall not observe any diligence in transporting you. Next stipulation, that the carrier shall not be liable for acts of robbers or thieves, even if or who did not act with grave or irresistible violence or force. Are those valid stipulations? Yes or no? Are they valid stipulations? The answer is yes. In a common carrier situation, they are not valid. But look at the problem very well in the bar. If it is a private carrier situation, those stipulations in 1745 are valid. You know why they are unreasonable, unjust, and contrary to public policy? Because in a common carrier situation, they are not valid. But they are valid in private carrier situations. So in other words, 1745 applies only to common carriers. What applies to private carriers are the stipulations of the parties. The strict policy in 1745 does not apply to private carriers. Well, I am not asking you to memorize 1745. You might suffer from mental indigestion. But I simply want you to know that they do not apply to private carriers. 1745. What are they considered by the law? They are considered as unreasonable. They are considered as unjust. They are considered as contrary to public policy. Let's try to paraphrase them. The first stipulation that is contrary to public policy, unreasonable or unjust, is what? That the carrier shall transport the goods at the risk of the owner or shipper. I will transport your goods, said the common carrier, but at your risk, not mine. Oh, that's bullshit. Look at that. The stipulation is clearly, evidently, and conspicuously void. What's the second one? That the common carrier shall not be responsible for the loss, deterioration, or destruction of the goods. Oh, that's void. That the common carrier shall not observe any diligence in the custody of the goods. Oh, that's void. That the common carrier shall exercise a diligence less than that of a good father of a family, blah, blah, blah. That's void. Take note of this. The stipulation cannot go below diligence of a good father. You follow? So even if there is a stipulation decreasing the degree of diligence, it cannot go below that of a good father of the family. Eh lalo na yung number 3. No diligence at all. That's very bad. No diligence at all. Kasi ang mababa sa ordinary diligence ay slight diligence. Ay yung number 3, no diligence. Wala talaga. Look at the next stipulation that is unreasonable, unjust, and contrary to public policy. That the common carrier shall not be responsible or liable for the acts or omissions of its employees. And that the liability of the carrier for acts of thieves or robbers who do not act with grave or irresistible violence or force shall be dispensed with or diminished. Look at the last one. It's almost scandalous. That the common carrier shall not be responsible for the loss, destruction of the goods on account of the defective condition of the car, blah, 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 blah. Oh, that's scandalous. So, that is void under a common carrier situation. But it is not void in a private carrier situation. Could you see the helicopter case in 1987? Here, the bar examiner presumed it was actually a private carrier. And let's see if the stipulation there is valid. Did you see 1987? Would you try number, it's either 8 or 9. Although my bet is number 9. I'm sleepy, so my memory is hazy. Number 9. Can I see it for a while? Okay, you listen to this, okay? So that you will know it does not apply to a private carrier situation. Okay. Here is a helicopter that was actually chartered to an election candidate. Now, it was chartered in such a way that it was a private carrier. In other words, it was like a bareboat charter. Okay? Bahala ka sa piloto, bahala ka sa provisions, bahala ka sa lahat. So, yun ang circumstance. You listen to this. Kaya pala hindi ko mabasa. Yung salamin ko nasa loob. During the elections last May, AB, a congressional candidate in Marinduque, chartered the helicopter owned by Lode Mining Corporation for use in the election campaign. AB, ito'y personal na gamit ng mining corporation. Pinaano lang sa kanya. AB paid LMC the rate normally charged by companies regularly engaged in the plane chartering business. In the charter agreement between LMC and AB, LMC expressly disclaimed any responsibility for the acts or omissions of its pilot or for the defective condition of the plane's engine. The helicopter crashed, killing AB. Investigations disclosed that pilot error was the cause of the accident. LMC now consults you on its possible liability for AB's death in the light of the above findings. How would you reply to LMC's query? I would reply to LMC's query as follows. Masyadong maarte ang sagot. Lode Mining Corporation may not be held liable for the death of B. A stipulation with a private carrier that would disclaim responsibility for simple negligence of the carrier's employees is a valid stipulation. So, it will not be responsible for the acts or omissions of its employees. Because the bar exams assumed here that the company was acting as a private carrier. Okay? There were only 2 questions in the history of the bar on that. The other one was 1984. It was the same. It was almost borrowed from 1984, but this time it was a bus. Privately chartered. The same stipulation, whether or not the stipulation exempting it from the acts or omissions of its employees would be valid. The answer was the same. If it is acting as a private carrier, the answer is yes. That's in 1984. 1984 and 1987, those were the 2 bar exams on that. On 1745's application. So, are we clear on that? But there is one question I would like to ask you. How would you know whether it is a public or a common or a private carrier? You look at the facts of the case, okay? Or sometimes it would be given in the problem. But if it is not given, then you have to use your common sense. Use the definition of a common carrier. You follow me? But you will have an inkling on what the examiner wants your answer to be. If the examiner says, let us take, for example, Victory Liner. It's a common carrier, okay? Nilis sa akin ang isang bus. Nung nilis sa akin ang bus, wala silang pakialam kung sinong driver, halimbawa. Or, kung kumuha ko ng driver sa kanila, ituturing na empleyado ko yung driver, hindi kanila. Ako ang may control sa direksyon ng bus. Ako magpo-provide ng fuel. Sa akin lahat ang control kung saan pumunta. Ang kanilang papel lang ay ibigay ang bus. The common carrier there, in most probability, in the mind of the examiner, would be acting as a private carrier. Complete control of the bus. It is similar to a bareboat charter. Kaya nga bareboat, dahil pag nilis sa iyo ang sinarter sa iyo ang boat, boat lang, walang provisions, walang crew members, etc. Para bang ikaw ang may-ari ng boat o ng vessel at that particular transaction, and they call it, you are the owner pro hac vice. You get my point? Owner pro hac vice. Pwedeng gawin yan sa bus. So look at the facts of the case. It will tell you. Or, pwede rin given na private carrier. So all those stipulations under 1745 would be considered as valid. But not when the carrier is acting as a common carrier. Are you still fine? Madali lang ang transpo, hindi nga dapat ito isali sa review eh. Kaya lang, isinasali. Sa totoo lang, wala naman kayong bagong natutunan ngayon. Alam nyo na lahat yan eh. Kasi yan ang essence ng review. You view again. Kaya pag alam nyo lahat ang sinasabi ko, that's a nice thing to do because you are reviewing. This is not first view. Review to view again. Review. Pare, ngayon ko lang alam yan. Hindi ka review, first view. Sagot mo, inggit ka. Ako first. Okay. Now look, let's discuss extraordinary diligence. I see it in your syllabus. You know, Article 1733 actually mentions the basic rule of diligence in common carrier situations. 1733. Look at it. That's your Bible. Common carriers are bound to observe. What does it say? Bound to observe extraordinary diligence. In what? In the vigilance over the goods and the safety of passengers. But there is a beautiful phrase, according to the circumstances of each case. Why did the law include according to the circumstances of each case? Because the meaning of extraordinary diligence cannot be put in shades of black and white. It cannot be put in watertight compartments. It has to be measured in accordance with the circumstances of each case. We cannot interpret it with pedantic rigor. I don't know why I use that word. That's too much. We cannot interpret the terms with pedantic rigor, with rigidity. It has to be flexible in accordance with the circumstances of each case. Even the term diligence depends upon circumstances. What is negligence? The opposite of diligence. Negligence is the omission of that. Come on. 1173, first paragraph. Negligence is the omission of that diligence required by the nature of the obligation. Listen to that. And corresponds to the circumstances of the person, of the time, and of the place. That's 1173. So extraordinary diligence has to be flexible in accordance with the circumstances of each case. Now, why? Why? Look at Article 1173. Why should a common carrier exercise extraordinary diligence in the vigilance over the goods and the safety of passengers? 1173 answers you. Because of the nature of its business. And because of reasons of public policy. Well, that is how to study caudal provision. So there are many things you learn under Article 1173, right? Does the law give another name to extraordinary diligence? O Tagalog yun, pinakamataas na diligence, Tagalog yun. O yung English na binibigay ng law. Tingnan nyo 1755 at may isang pangalan. <clears throat> 1755 nga ba? The utmost diligence of very cautious persons. See, the utmost diligence of very cautious persons. Pero yung utmost diligence sa 1755 applies to passengers. Is it that? Yes. As far as human care and foresight can provide. Your transportation law is still long. If you look at this is long. It's only short the way it is typed, but it is long. It's very kilometric topics. Tapos, ang itatanong, dalawa lang. Gawin na nilang 5. Pero sigurado may essay yan sa transport. May essay. I could feel it. I could feel it. There will be an essay question. Okay. What is the significance? You know, what has been the implication of that duty of extraordinary diligence? You know, that duty of extraordinary diligence is actually the very essence of its liability. It's the source of its liability. The extraordinary diligence duty. And because of that, it has an effect. Because of that, the law created a presumption of negligence against the common carrier. That's why when you are being asked in the problem whether or not the common carrier is liable under a particular situation, you've got to let the examiner know by implication that you know the presumption of negligence. Because the examiner wants to know whether or not you know the presumption. That's why in your head, you must always ask this. Is he liable? Answer, presumed to be liable. Because it is presumed to be negligent. Then the next part of your brain will say, does it have a defense? That is the thought pattern. But the first part of your brain would say, he is liable. Because presumed to be liable. Could you look at 1735, please? Never mind the letters mentioned in the first part of 1735 because it refers to the defenses in 1734. But look into the next part of the line. Common carriers are presumed to be liable when goods are lost, destroyed, or deteriorated. They are presumed to have been at fault. See? Have been at fault or have acted negligently. You see that presumption? Kawawa naman ang common carrier business. Now, let me ask you, because we are in 1735, suppose there is a valid stipulation limiting the liability of the common carrier and reducing that duty of extraordinary diligence. Let us assume it is a valid stipulation. Will that presumption of negligence still apply even if there is a stipulation limiting the degree of diligence of the common carrier in relation to the goods? Yes or no? The answer is yes. The presumption of negligence will still apply. How do you know that? It's a direct caudal provision. You look at 1752. Although it's several provisions away, it's 17 provisions away. But it confirms our theory that the presumption of negligence will still apply. What is the defense allowed by the law against that presumption under 1735? Observance of extraordinary diligence, which is a very vague concept. Observance of extraordinary diligence. You know, there was a case of Metrobus Corporation in 386 scrap. Sabi ng Metrobus Corporation, we have observed extraordinary diligence. We have memos on the training of our bus drivers. We have stringent selection process. Look at our documents. These prove our exercise of extraordinary diligence. Asar din ng Supreme Court sabi ng Supreme Court, puro lang yan papel. Ano ba ang ebidensya nyo na those policies are strictly followed and implemented? Wala kayong ebidensya. You did not exercise extraordinary diligence. Kawawa naman ang bus company. What the Supreme Court says, that is it. So it's very difficult. It's a nebulous term. It's a very vague term. Observance of extraordinary diligence as a defense. What is meant by extraordinary? Bawat pasahero ay kakargahin mo, susubuan mo, pupunasan mo ng pawis. Kawawa ang business ng common carriers. At sa ibang bansa, medyo hindi ganun ka-strict. Pati sa mga motor vehicle drivers. Dito sa atin, assume na pag ikaw ang bumangga sa pawitan ng isang kotse, ang bumangga ang may kasalanan. Sa California, hindi. Bumangga ka dahil masyado kang malapit. Kahit nagpreno yan ng bigla, kung ikaw ay nag-observe ng safe distance, hindi ka bumangga. Iba talaga dito sa atin. Total, common carriers din. Okay. Dito, magagalitan ka ba? Okay. Dito sa atin, ito ang main road. Ito ang feeder road. Yung maliit na road. Dito sa atin, kung sino nakauna, siya mauna. Kahit ito ang dapat may right of way. Kung tutusin natin at titingnan natin ang ating batas, may right of way talaga. Ibig sabihin, lahat ng vehicles dito, uubusin muna bago kayo gumanon. Eh dito, sa practice, hindi. Kung sinong nauna ang uso, yun na. Galit pa. Yung galing sa eskinita, galit pa. So, halimbawa sa California, where I lived for almost 11 years, pag ikaw ay nasa main road, at ito biglang umarang at binangga mo, siya ang magbabayad sa'yo. Because he has no right to be there. Dapat maghintay siya. Na-clear ang main road bago tumawid yung mga nasa maliliit na road. At dito hindi. Kaninong uso ang nauna? O di, pahabaan ang uso. O, see? Iba talaga. Dito, kahit hindi ka marunong mag-drive, may driver's license ka. Doon, Babagsakan ako ilang beses. Naalala ko yung pinsan ko, ang yabang-yabang. Total, common carriers to eh. Na naging private carrier. Ang yabang-yabang. Uncle. Pinsan, ilang beses ka kumuha ng exam? Sabi ko, chicken feed lang yan, maingat ako eh. Minsan lang ako kumuha ng driver's exam, pumasa na ako eh. Ako. Isa din. Okay. Di sinamahan ko siya. Okay. Di na drive na siya kasi na-perfect niya yung theory. Mayabang talaga, na-perfect niya yung theory. Yung test, yung written test, na-perfect niya. Ang hirap-hirap yun. Na-perfect niya. Yabang-yabang. Okay. Ito na ngayon ang DMV. Department of Motor Vehicles. Sa atin, LTO. Is it not? Okay. Andito na siya. Okay. Sabi ng instructor, ng nag-test, yung examiner, nakaupo na. Okay. Dinig na dinig ko eh. Kasi bukas yung binala. Start engine. Brum. Sabi niya, brum, brum, brum. Pinababa siya. Bagsak. Hindi ka gumaganong brum, brum, brum. Doon sa California, that is discourtesy. Bagsak siya. In-schedule after 1 week. Tandaan mo yan ha, walang brum, brum, brum. Pero hindi ko siya tinuturuan ng iba pa. Dahil mayabang eh. Okay. Okay, next. Start the engine. Brum. Wow. May silencer na. Brum. Okay, let's go. Andar siya. Wala pang isang buong gulong umandar. Pinababa na siya. Bagsak. Bakit? Hindi naglagay ng seatbelt mo na. Sabi niya, ganito pala ito. Oo nga, ay yabang mo eh. Okay. Okay. Pwede pa, bawal to sawa yan hanggang sa matuto ka. Okay, third time. Sabi ko, maglagay ka ng seatbelt. Tatandaan mo, sasabihin sa iyo ang hand signal. Kasi kung mawalan ka ng light, paano ang hand signal? Okay. Pagkakaliwa ka, gaganong ka. Pagkakanan ka, gaganong ka. Yun ang standard. Pag ikaw titigil, gaganong ka. Okay? Okay. Practice. Kakaliwa, gumagano siya. Hindi Pilipinas to. Anong ganon? Sprinkling? Wala. Ano ka, bombero? Ganon. Sabi ko, ganon. At saka, yeah. Okay. Okay ha. Pag umandar ka, lagay ka ng seatbelt. Sus, 10 beses yata bago siya kumasan. Lagay ka ng seatbelt. Pero meron akong hindi tinuro sa kanya. Okay. Ganon na yan. Start engine. Maluma na yan. Okay. Seatbelt. Hand signal. Galing. Snappy pa. Nakita niya ako. Kindat pa siya. Okay. Andar na. Pinababa. Baksak. Alam niyo kung bakit? Hindi pinalagay ang seatbelt ng basero. Biro mo yan. Okay, ilang beses na bumagsak. Okay, marami na. Okay. So, tinuro ko sa kanya, huwag kang umandar ng lahat ng pasahero mo walang seatbelt. Okay, tatandaan ko. Okay, dito na. Ito, sidewalk. Okay, sidewalk. Ito ang main road. Okay, main road. Okay. So, andito na siya. Nakaandar na siya nang hindi siya mula sa garahe. Nakaandar na siya. Sabi ko, uy, maganda-ganda na. Mukhang papasa na. Pagdating dito, diretso. Plak! Pinababa siya. Bagsak. Dahil sidewalk to. Bago mo tawirin ang sidewalk, tumigil ka. Dahil baka may tao o may bisikleta. Bagsak. Umiiyak ka. Makakapasakay ako. Oo, 10 beses yan. Unti-unti ka lang. So hanggang nakakuha na rin siya. Sus, nang makakuha ay nag-blowout ng katakot-takot. See? Iba sa atin. Sa atin, walang test. Uy, bigyan mo naman si pinsan ng lisensya ha. Ako na bahala sa'yo. Yan ang transportation law dito. Marunong ka na bang magpa-atras ng kotse? Hindi pa. Ba't may lisensya ka? Kasi Puro abante lang ako eh. Hindi ako atras. Okay, look at this. Look at 1756. We were talking about goods. Now we go to 1756. And 1756 talks about passengers. See? Also extraordinary diligence, right? And if something happens, if a passenger is injured, dies, etc., is there also a presumption of negligence against the common carrier? Yes. But do you notice something? This is quite disappointing, right? Why? Goods and passengers are placed on the same footing. It's quite dejecting to know that you take care of goods with extraordinary diligence and you also take care of persons with the same extraordinary diligence. We are the same as goods. Inanimate and animate objects, they're just the same. But there is a saving grace. Look at 1744. And compare it with 1757. That's the saving grace. At least, that makes us happy. In 1757, the responsibility for the safety of passengers cannot be lessened by stipulation. Cannot be lessened by posting of notices. Cannot be lessened by stipulations and tickets. Get my point? Look at 1744. The extraordinary diligence can be lessened by stipulation, provided the three requisites are present. Must be in writing, signed by the shipper, blah blah blah. Next, supported by a valuable consideration other than the services rendered by the common carrier. And the stipulation must not be unreasonable, must not be unjust, must not be contrary to public policy. At least, nakalalamang na tayo because of 1757. But can there be a stipulation involving passengers that would pose an exception to 1757? Yes, look at 1758. The stipulation could be allowed when the passenger is carried gratuitously. But to lessen the obligation of the carrier, there must be a stipulation. There must be a stipulation. If there is no stipulation, a mere gratuitous carriage will not lessen the responsibility. The gratuitous carriage only allows a stipulation, lessening its responsibility. But remember, go back to 1745. There cannot be a stipulation where the carrier will exercise diligence less than that of a good father of a family. You look at number 4 of 1745. That would be void in a common carrier situation. See it? And where the carrier will not observe any diligence, oh, that's scandalous. It cannot be done. Can you follow me? And it cannot also be a stipulation that would exempt the carrier from willful acts or gross negligence of its employees. Did you see that? Okay, now you might be asking the bar, my fare was reduced by the common carrier. Will that justify a lessening of the diligence? No. Did you see that? Did you see that? What provision is that? Yes, 1758. A reduction in fare does not justify limitation of the carrier's responsibility. Are these the only presumptions of negligence in the law? 1735 and 1756? The answer is no. The answer is no. There are some presumptions of negligence, but not necessarily common carriers. Oh, you cannot avoid talking about some aspects of torts and damages here. There is a presumption of negligence in 2184. There is a presumption of negligence in 2185. I'm sorry, I'm closing my eyes. I'm trying to recall. There is a presumption of negligence in 2188 of the Civil Code. There is also a presumption of negligence, inuhuli ko ito kasi mas importante, is 2180 of the Civil Code. Your first break will be at 10:35. It's 10:34. And there is another presumption that is not even found in the law. The presumption when res ipsa loquitur applies. See? Okay? Can we have a break for a while? Yes. I know you like it. traffic rules or guilty of reckless driving at least twice during the immediately preceding 2 months, there is a presumption of negligence. The presumption, however, is not conclusive, okay? It's rebuttable or it's prima facie presumption. So, let me repeat that one in 2184. If you have been found guilty of violation of traffic rules and found guilty of reckless driving at least twice during the immediately preceding 2 months, there is a presumption of negligence. There is another presumption of negligence in 2185 where at the time of the mishap, you are actually violating a traffic regulation. There is a presumption of negligence. let's say, there was a head-on collision between two vehicles, and one of them was actually going the wrong way. Going the wrong way is a violation of a traffic rule. There is a presumption of negligence against the person violating the traffic rules. There are some presumptions of negligence also under the provisions on quasi-delicts, but do not necessarily involve motor vehicles. Like in 2188, presumption of negligence when there is injury or death because of possession of dangerous weapons or substances. So let's say I'm a gun owner and my gun accidentally caused injury to another person. It is not a part of my occupation to hold a gun and to handle a gun. A presumption of negligence arises against me. That's 2188. But that presumption will not arise against members of the armed forces who actually handles guns as part of their occupation. Will not apply to the Philippine National Police, whose occupation involves the handling of guns. But like me, a civilian, whose occupation does not involve handling a gun, and I simply go to the firing range to fire, then there is a presumption of negligence because it is not inherent to my occupation. 2180 will be the topic of a special discussion in a few moments, because a presumption of negligence also arises on the part of those people responsible for others under 2180. There is a presumption of negligence also under the doctrine of vicarious liability. That's 2180 of your Civil Code, vicarious liability. It's also sometimes called in American jurisprudence as the doctrine of imputed negligence. The negligence of the people below is also imputed as the negligence of the people who has supervision over him. That's 2180. If you look at 2180, the last paragraph will tell you that you can only be free from such responsibility if you show that you observe the diligence of a good father. Meaning, the presumption is there, and the diligence of good father is only a defense. But there is a beautiful presumption which an examiner could use for transportation laws, the doctrine of res ipsa loquitur. It's not found in the code. But do you realize that for the first time in the history of our laws and rules, in 2007, the words res ipsa loquitur has been enshrined in our rules of court in Section 8 of Rule 65. If you file an unmeritorious petition for certiorari, the Supreme Court can impose disciplinary action against you on the basis of res ipsa loquitur, meaning the unmeritorious petition is actually patent on its face and the pleading speaks for itself. That seems to be arbitrary. The pleading speaks for itself. Res ipsa loquitur, that's found in Section 8 of Rule 65 already. I don't know, you have your rules of court right now? Oh, that's history for you. After your traumatic experiences. See, it's there. But res ipsa loquitur is not actually a codal term. It is a common law term based on... Can I talk about it for a while? Because this is negligence, and our transportation law has negligence and diligence as an integral part of its lesson. You may, I don't know if you will take this up in your torts and damages. I am not your lecturer there. I used to be your lecturer in torts. And actually, res ipsa loquitur actually originated from an 1863 case in England. Not here, not here. We borrowed this. Oh, when you were taking up torts and damages, you, 2180, 2180 of your Civil Code, 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 2180 of your Civil C You heard about this case. Byrne versus Waddell. See? It was about a guy who was walking in the sidewalk. This is the sidewalk of a lonely but beautiful street in England on a sleepy, hazy Sunday morning. There are only 3 people. 2 people here also walking on the opposite side of the street. And here was Mr. Byrne walking here. There was a warehouse here. Okay. While he was enjoying his morning walk, you know what happened? A barrel of flour fell on his head. A barrel is actually around 40 to 42 gallons if it is liquid. So, if it is flour, 40 to 42 gallons of flour. And what happened to him? He was terribly injured, of course. He was hospitalized for 3 months. And so what happened was a barrel from this warehouse rolled onto him. He was rendered unconscious. He was severely injured. And he had witnesses. The 2 people on the opposite side of the street looking at him. So, when he recovered, he sued Mr. Waddell, the owner of the warehouse, under quasi-delicts. Their equivalent of quasi-delicts. So, the basis was negligence. So, he presented the testimony of the physicians to attest to his injuries and the eyewitness accounts of the 2 witnesses. On the basis of damages based on negligence, he lost the case. When the barrel of flour fell on him, he almost died. It was a near-death experience for him. When he lost the case, that was the second near-death experience. He must have seen a tunnel at the end, or a light at the end of the tunnel. Near-death experience. You know why the trial court said you lost the case? The reason was very simple. The court said, you're suing Mr. Waddell for his negligent acts. You have only proven, number 1, you were injured. Number 2, you have proven the extent of your injuries. You have proven the amount of money you spent to recover. But you were not able to prove how he handled the barrel. You were not able to prove how negligent he was in handling the barrel. He who alleges negligence must prove the details of the negligent act. You were not able to prove it. We are sorry. You lose the case. Again, he almost died. So he appealed. He appealed. The Court of Appeals, their own equivalent of the Court of Appeals, said, we affirm the trial court. You allege negligence, you must prove the negligent acts. You were not even able to tell us how Mr. Waddell handled the barrel, how it rolled out of his hands, then going to you. No, we affirm. That was his 3rd near-death experience. He had one recourse, England's equivalent of the Supreme Court, which at that time was called the Lord of the Exchequer. Exchequer means money, treasury. I don't know why. So, he appealed. You know, if you read the originals of this, I was in an American law firm when I read the originals of this in old archaic English. That's why I had to call our librarian for a down-to-earth interpretation. And she wrote the interpretation because the English was old. So if we translated Tagalog in a language with brutal frankness, it says this way, kayo palang trial court at court of appeals, mga tangengot kayo. Yan, yun. Paano naman malalaman ng tao kung paano hinandle yung barrel? Eh, nasa ibaba siya. Nabulaga na lang siya ng bariles. And he was rendered unconscious. Tapos hihintayin niyo siya na idetalye kung paano hinawakan yung bariles sa itaas? Ano kayo? Ang bariles ay hindi gagalaw kung walang naghandle. Ang bariles hindi gugulong kung walang nagkamali sa itaas. Ang bariles hindi gugulong kung hindi negligent ang in charge ng mga bariles. Kaya nahulog yan dahil negligent siya. The event speaks for itself. Binago ng kano, the thing speaks for itself. The fact that it fell indicates negligence. Presumed negligent si Mr. Guadel. Because ang paghulog ng bariles sa kalsada, hindi yan pang-araw-araw na occurrence. Nangyayari lamang yan kapag merong negligence. Kaya siya, nahulugan ng bariles, si Mr. Guadel at ang kanyang mga tauhan, negligent. Meron na ngayong presumption of negligence. Isinilang noong 1863 ang res ipsa loquitur. The thing speaks for itself. Kaya gumawa kayo ng t-shirt pagpunta sa bar, shall I be a lawyer? Nakalagay sa likod, res ipsa loquitur. Okay? Walang gumagawa nun. Nakagawa. Now, you get my point? This is the birth of res ipsa loquitur. You create a presumption of negligence from the very fact, number one, that the event does not normally occur had it not been for the existence of negligence. Number two, the management of the affair that led to the incident was under the full control of the defendant. Res ipsa loquitur. Well, it was borrowed also by America because when England says this, America borrows it. This was about, you don't have to write this. I'm just telling you a short history of this. This was an old American case about a vivacious, bouncing, healthy lady. She was beautiful. She walks with the grace of the summer breeze, according to the story. And then one day, she suffered from abdominal pains. She went to a surgeon. And because she went to a surgeon, the surgeon would do what he is trained to do. Open you up. Oh, her abdomen was opened up. And lo and behold, the surgeon saw a form of ulcer in her intestines. So, her large intestines actually had some ulcers in it, so ginamot. So, the lady was bouncing again, walking with the grace of the summer breeze, but only for 3 months. After 3 months, she had a slicing pain. She went back to the surgeon. You know what the surgeon would do? Open her up again because that's his specialization. And she was opened up. And so, eureka, you know what was found? A small scalpel was left from the first operation. He was sued by the lady. The defense of the doctor was funny, fortuitous, beyond his control. And the Supreme Court of that state said, it's not fortuitous. It does not normally happen. The fact that you left a tiny scalpel there is an indication that there was negligence. It borrowed the case of Byrne versus Guadel, where the Supreme Court of that state said, res ipsa loquitur. Now, did we borrow res ipsa loquitur? Of course. That's predictable. Oh, there are many cases here. Espiritu versus Electric Power Corporation. This happened in Laguna, but that is not very popular. The more popular case is Republic versus Luzon Estevedoring. Have you heard that? 21 scrap. This happened in the early 1949. Oh, we were not yet born. Please include me there. But if Dean Hara were here, he would be included. Dean Ortega, included. Me? No. Okay. You know, the Nagtahan Bridge that you see now did not used to be that way. It was not concrete, it was not steel, it was made of wood. And so here comes two barges, owned by Luzon Estevedoring. One barge was named Bangus, milkfish. And the other barge was named Barbero. Barbero? Nagaputol ng buhok. Barbero. They were towing a barge. And you know what happened? One post or pylon of the bridge was hit by the barge. And that bridge is owned by the Republic of the Philippines. And so the case Republic versus Luzon Estevedoring. The defense of Luzon Estevedoring was fortuitous, the current of the Pasig River, because the river was flooded. You know what the Supreme Court said? Palagi naman nagfa-flood dyan eh. Wala namang barge na tumatama sa bridge. Ang bridge, hindi gumagalaw. Kayo ang gumagalaw. Kaya bumangga dahil ibig sabihin negligent ang pang-handle ng tugboat at ng barge. The thing speaks for itself. Res ipsa loquitur. See? Naalala niyo ang Africa versus Caltex? Those of you who grew up in Manila, somewhere in Rizal Avenue, know about a street crossing Rizal Avenue called Antipolo Street. I remember when I was a kid, that Antipolo Street was the place of the biggest houses in that area. It used to be like the Forbes Park of Manila. And at the corner was a Caltex station. And while a tanker of Caltex was hosing gasoline into the underground storage, it exploded. The Supreme Court said, res ipsa loquitur, explosion of underground tanks of gasoline stations do not normally happen. It was within the full control of the Caltex station, then res ipsa loquitur. Okay, presumptions of negligence. If someone tells you that in torts and damages, you know what it means. Now, one very important topic according to your what you call the syllabus is the liability of common carriers. What is the basic source of liability of common carriers? When I say basic source of liability, you're talking about the sources of obligations, okay? You have law, you have contracts, you have quasi-contracts, you have acts and omissions punished by law, you have quasi-telex. Let's try to illustrate this one because the cases on common carriers involve not only cases against the common carrier but against his agents. Okay, so let's try to do something here and let's try to explore some possibilities, okay? What are we going to use? Airplane. Mahirap abutin ng airplane, masyadong mataas, okay? Jeep, masyadong maliit. Let's use a bus. Okay. Okay. Let's name this series lines. The yellow one or the blue one? Never mind. Whatever. I'll use Victory Liner. There are more buses here. Okay. Victory Liner Incorporated. This is bus number 007. The driver looks like James Bond. Okay? The driver, his first name is Carlos Ortega. You know him? Okay. The passenger, his first name is Virgilio. I do not know his last name. Just passenger Virgilio. Okay. And a pedestrian here. Okay. I have no name. Can you give me a name, Saibit? Mr. Makarambon, can you give me a name? No, not Triano. I'm the judge. Okay. His name is Ferdinand. Okay. He was holding a book in remedial law. You know, while driving, you know what he was doing? He was holding a book in criminal law. And Rule 110 of the Rules of Court. Yeah. He was reading while driving and memorizing some provisions in Rule 116, and he was driving, closing his eyes. Okay, so Ferdinand suddenly crossed the street. What happened? He stepped on the brakes. Okay? And because of the inertia at rest, you know the inertia at rest? Virgilio was seated here, suddenly darted to the windshield. His head embedded on the windshield. And he was there, his legs was... You caught me immediately, okay? Was there hanging in the air. Okay. And Ferdinand was hit. But he was hit. He was not terribly injured. Okay. Okay, questions here would be this. Let's start with Ferdinand. He wants to sue. Okay? And he said he wants to sue the driver. And the driver is only an agent of the common carrier, because the driver is an employee. So, pedestrian versus driver. What could be the basis of the cause of action of the pedestrian against the driver? Is it possible to sue him based on a quasi-delict? The negligent act or omission causing injury to him? In other words, you are going to assess the quasi-delict in relation to the elements of a quasi-delict. So if you're asked, is Mr. Driver liable for a quasi-delict under, or let's say, in favor of the pedestrian? How would you attack the problem? You look at the elements. You tell the examiner the basic elements of a quasi-delict under 2176. That's pure and simple common sense. Now, did he perform an act or omission? He performed an act. Was that act one that constitutes fault or negligence? Yes. Is his negligence the proximate cause of the injury of the pedestrian? Yes, there is the last element. There must be no pre-existing contractual relationship between the parties, right? All the elements are present in the case under consideration. The driver, therefore, is liable for a quasi-delict. Correct? Okay. Can the pedestrian also initiate a criminal action against the driver? Can he cause the filing of an information against the driver under the revised penal code? Yes, very good class. I'm impressed. It's the same act causing injury, but that single act caused a quasi-delict and at the same time a violation of the revised penal code. Now make that clear in your minds, because this could be in remedial law. This was already asked in remedial law in relation to litis tendentia topics and in relation to presumptions of negligence. You follow me? Okay. Why could there be a suit based on a quasi-delict? You know the elements. Why could there be a suit based on the revised penal code? Very simple. There are two modes by which a felony is committed. Article 3 of the revised penal code. One is by dolo. What is dolo? ¿Qué quiere decir dolo? Señoritas, vamos a ver. What is dolo? One committed with malice or deliberate intent. What is culpa? One committed with imprudence, negligence, lack of foresight, or lack of skill. What do you call a felony called culpa under the last parts of the revised penal code? Under 365 of the revised penal code, to be exact, you call it a quasi-offense. And a quasi-offense is called criminal negligence, right? Okay. Now, Could the pedestrian pursue a criminal case based on reckless imprudence against the driver and at the same time pursue a case of quasi-delict against the driver? Yes or no? The answer is yes. They are separate and distinct from each other. Maybe you should read 2177 of your civil code on that for us to understand what this means. Now, let me just read this, just to impress this in your minds. I hope I could find 2177 here. Okay. Listen to this. 2177. I cannot find it. There it is. Responsibility for fault or negligence under the preceding article, which means 2176, is entirely separate and distinct from the civil liability arising from negligence under the penal code, but the plaintiff cannot recover damages twice for the same act or omission of the defendant. The remedies could be pursued simultaneously. There is only one recovery. Is there any part of the rules of court which reinforces 2177? Yes, Section 3 of Rule 111, talking about the independent actions under 32, 33, 34, and 2176. You remember those, children? Is there any other supporting provision in the Civil Code related to 2177? Yes, Article 31. I'm looking for it. You listen to this. This Article 31, when the civil action is based on an obligation not arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceeding and regardless of the results of the other. This is Article 31 of your Civil Code. Let me just try to explain this very, very quickly. Okay. When he files an action for reckless imprudence resulting in physical injuries against the driver, there is an implied institution of a civil action, right? Okay. This civil action arose from the offense. This is one arising from the offense charge. When you file a quasi-delict suit against him, the quasi-delict does not arise from the offense charge. The quasi-delict is an independent source of liability under Article 1157 because a delict is separate from a quasi-delict. And a quasi-delict has a substantivity of its own, separate and distinct from the civil liability arising from the offense charge. But you cannot recover twice because the sources of obligations came from the same act. Okay? Now, the passenger now wants to sue Victory Liner Incorporated. Can the pedestrian sue the passenger? Oh no. Can the pedestrian sue Victory Liner Incorporated on the basis of a breach of a contractual obligation? Of course, no. Because he is a pedestrian. He is not a passenger. Breach of contract? No. There was one who answered before, and I simply smiled. There could be a breach of contract, a breach of his social responsibility to be careful. Wow, it's more poetic than legal. Okay. The writer should have been a literary writer. Okay? Not a legal writer. Could there be a suit against the carrier by the passenger, by the pedestrian, based on a quasi-delict? When the driver committed a quasi-delict, negligence in driving, did Victory Liner, his employer, also commit a quasi-delict? Yes, but the carrier's quasi-delict was not negligence in driving. The negligence in driving was committed by the driver. The negligence of the common carrier is negligence in the selection and supervision of the driver. Let's read the introductory portion of 2180 so that we would do it very exactly. So this gives us the principle that the one who is negligent, who really directly caused the injury, is not the only one liable, but also the person who supervises him. So what does 2180 tell us? The obligation imposed by Article 2176 is demandable not only for one's own acts or omission, but also for those of persons for whom one is responsible. Is the employer responsible for the acts of the employee? Yes. Did the employee commit a quasi-delict? Yes. If he did it in the exercise of his function while doing his duties as such, then the employer is also liable for a quasi-delict. But the quasi-delict of the employer is not of the same kind as that committed by the driver. Its quasi-delict is negligence in the selection and supervision. You get the point? Okay. Now, let us suppose the driver is sued based on a quasi-delict, and the driver loses the case. Let's forget the criminal action first. Suppose he was only sued based on a quasi-delict by the pedestrian, and the driver loses the case. The court said, you pay the pedestrian Ferdinand these damages. There was a writ of execution. He was insolvent. Can the employer, common carrier, be held subsidiarily liable? Answer, no. There is no subsidiary liability when the employee is sued based on a quasi-delict. If you want the employer to be liable and you are suing the driver based on a quasi-delict, you have to implead the common carrier as an employer. You have to implead. This is an action in personam. You need jurisdiction over the person of the common carrier. There is no law which imposes a subsidiary liability on the employer where the employee is sued based on a quasi-delict. You have to implead the employer. Question, can they be joined under one complaint? Pedestrian versus common carrier and employer and employee driver. Yes. Why? It arose out of the same transaction or occurrence, the same accident, the same incident. There is a proper joinder of cause of action, a proper joinder of parties. By the way, the cause of action against the employer is different from the cause of action against the driver. But they can both be joined under one complaint because the injuries of the plaintiff arose out of a single accident involving the negligence of the driver and the negligence of the common carrier in the selection and supervision of the employee. There is no subsidiary liability. You cannot make the employer liable if he is not impleaded. Okay. Suppose the driver is sued criminally. And remember, there is also an implied civil action to recover the civil liability arising from the offense charge. What will be the criminal case? Reckless imprudence resulting in serious physical injuries, for instance. Or let's make it less serious. We're too cruel to make it serious. The driver was convicted. And because he was convicted, he was also adjudged to be civilly liable. And necessarily, there would be a writ of execution on the civil aspect of the case. Get my point? Like a civil case. But what happened? The sheriff returned empty-handed. No property. Nothing at all, except the clothes on his back. Well, signature, yes, clothes, but they are exempt from execution under Section 13 of Rule 39. He had no jewelry. He did not even have a prepared tombstone with gold writings. No. Nothing. He had no cows. He had no horses. He had no carabaos. No beast of burden except a wife. A battered wife. So he is insolvent. The civil liability could not be satisfied. Is there subsidiary liability of the employer this time? The answer is yes. The subsidiary liability arises when the employee is sued criminally, he is insolvent, and he cannot satisfy the civil aspect of the case. There is subsidiary liability. Under 102 and 103 of the Revised Penal Code, that is where the subsidiary liability comes in. Remember, the subsidiary liability of the employer arises when the employee is sued criminally, not under a quasi-tele. But you must indicate that he was convicted. You must indicate that he cannot satisfy the civil liability because of his insolvency. Run after the employer. Next question. Can you make him liable even if you do not file a separate case against the employer? When I was a student like you, I asked my professor this way. I was scolded, but he was right. And I didn't mind this scolding. Sir, may I ask you a question? Yes. Hurry up. Sir, I have reservations as to the liability of the employer. Because when you get from him the subsidiary liability for damages, you are enforcing a suit in personam. But if you are enforcing a suit in personam, you need jurisdiction over his person. But he was not pleaded in the criminal case. So how would the court have jurisdiction over the civil aspect involving the employer? Answer, tanga. Your reasoning is procedural. Yes, sir. And tell me, negro. I was dark. Tell me. Where did the subsidiary liability come from? Did it come from the rules of procedure? No, sir. It came from the Revised Penal Code. Do you know the provisions? Meekly, I said, yes, sir. Articles 102, 103 combined of the Revised Penal Code. There you are! Is the Revised Penal Code procedural? No, sir. Is 102, 103 substantive law? Yes, sir. Is it not that substantive law will prevail over procedure? Yes, sir. It is substantive law which makes him subsidiarily liable. Tanga ka. Your reasoning is procedural. It's the substantive law itself which makes him automatically subsidiarily liable. Jurisdiction over his person. Thank you, sir. I will not tell you who he is, okay? I love him. In other words, the subsidiary liability of the employer is already impliedly, automatically written in the judgment and the criminal case that if the employee is insolvent, the employer will be subsidiarily liable because of the provisions of substantive law, the Revised Penal Code. And the employer is bound by the judgment, not only as to the amount, but as to its finality if the accused does not appeal. Next question. According to the famous case of Pajarito versus Inyeres and the famous case of Philippine Rabbit versus People, can the employer appeal if the accused does not appeal from the conviction or the civil aspect of the case? Answer, no. It is the prerogative of the accused to appeal. Because only the accused can waive double jeopardy, not anyone else. Because if you appeal the criminal case, you are exposing yourself to another danger. Get what I mean? Only the accused can expose himself to danger, not the employer. The amount is final. That's why, you know what the Supreme Court said in many cases? You employers, it is your duty to protect your employees who are sued criminally. Because if they lose and they are insolvent, and they are always insolvent, you're going to be subsidiarily liable. Are you still alive? Yeah. Okay, remember this one. If you sue the employee based on a quasi-delict, he is insolvent, there is no such thing as subsidiary liability of the employer. The subsidiary liability only arises when the employee is sued criminally and he cannot satisfy the civil damages imposed against him. Now, let's try to erase this one. Let's go to Virgilio. We were only talking about Ferdinand. Who is Virgilio? Oh, I'm not asking you the last name. That's blasphemous. We're asking you who he is. He's the passenger, right? Okay. Can the passenger sue the driver? Yes. The same was a delict, criminal action, correct? Now, but we are more concerned with this. Victory Liner Incorporated. Oh, I didn't realize it's almost 12. I discussed this so animatedly, I forgot everything. I even forgot my name. When I'm before you, I forget everything. There's only one thing I don't forget, love. Ah, you are salvaje. Okay, look. What is the normal suit of a passenger against a common carrier? What's the source? Contracts. Very good. Breach of contract. Okay. Do you know that this was a topic not only in remedial law, but also not only in civil law or commercial law, but even in procedure? You know, when I was talking about cause of action, I remember giving you a sample. 2004 question. Number 8, letter A. On remedial law. I remember giving you that. Can I repeat that for this lesson? Okay, here is a passenger. He took a bus, a passenger bus, from Monumento down for Makati.
Thank you.
But then there was a collision along the way. He died. And when he died, the only son and heir sued the common carrier based on breach of contract of carriage. He presented the following evidence. Number 1, that his father was a passenger. And number 2, that his father was not brought safely to his destination. In fact, before he could reach his destination, he was called by the trumpets of the angels. You know what the common carrier did dahil remedial law ang ginamitan? After the plaintiff presented his evidence, the defendant filed a demurrer to evidence on the ground that under the facts and the law, the plaintiff was not entitled to relief because there was no evidence adduced of the negligence of the common carrier. Decide. Yan. If you are answering it in commercial law, your answer would be, there is no need to prove the negligence because it is presumed. If you're answering it in remedial law, there is no need to prove negligence aside from the presumption of negligence because a suit based on a breach of contract does not include negligence as an element, and that there are only two elements of a suit based on breach of contract. Number one, the existence of the contract, and number two, the breach of contract. Well, that was the example in remedial. Okay, we are in commercial law using 1756 presumption. So, based on breach of contract. Now, another question that should be asked is this: is it possible to sue the common carrier based on a quasi-delict even if there is a pre-existing contractual relationship between the parties? Diba, there is a contract between the passenger and the common carrier. Can there be a quasi-delict suit? Yes, under this situation, the passenger could sue Victory Liner under a quasi-delict on the basis of its negligence in selecting and supervising his employee driver. On that score, the cause of action will not be based on contracts. The cause of action will be based on the negligence of the employer in the selection and supervision of the driver. There is no problem with that. Now, if there is a suit based on contracts, is the negligence of the employer presumed? Come on. If the passenger sues Victory Liner based on breach of contract, is the negligence of Victory Liner presumed? Come on, we're hungry already. Yes, because of 1756. Say, presumed negligent. It is presumed negligence, presumed to have been at fault. Now, if you sue the common carrier based on quasi-delict, what will be the article that you will use? 2180 of the Civil Code. That fourth or fifth paragraph which begins with employers are liable. Is it not? Okay. Question. Do you have to prove the negligence of the employer under the suit based on a quasi-delict? Answer is no. It is also presumed because of the implication of the last paragraph. Look at 2180. I'm going to read it to you. I cannot find it. The responsibility treated in this article shall cease when the person mentioned above prove that they observe all the diligence of a good father of family to prevent damage. It shall only cease if there is a proper defense. Therefore, the presumption is there, but it could be rebutted by evidence of diligence of a good father. That's why when the employee commits an act of negligence, according to the Supreme Court, in 386, Metro Manila Bus Corporation, it says, when the employee commits an act of negligence, there arises a presumption juris tantum that the employer has been negligent in the selection and supervision of the employee, subject to a defense of diligence in the selection and supervision. Okay, next question. Can I ask some more questions before I let you go? And you come back at 12:30? No, I'm just joking, you know that. Okay. Can I ask one more question? The employer, Victory Liner, was sued based on breach of contract. Can it invoke the defense of diligence in the selection and supervision of the driver? Come on, you're very silent. Look at 1759. Look at the second paragraph. You cannot. 1759 paragraph 2 says that the liability of the common carriers does not cease upon proof that they exercised all the diligence of good fathers elect. This is not available when the suit is based on breach of contract. But this defense is available if sued under 2180 based on a quasi-delict. The defense is not available when the suit is based on breach of contract. Let's call it culpa contractual. It is not available. But the defense is available when the suit is based on culpa aquiliana, because of the last paragraph of 2180 of the Civil Code. Are you alright? Are you alright? Okay, remember that defense. When can you use the defense of diligence in selection and supervision? If the suit is based on culpa aquiliana or quasi-delict, specifically Article 2180. It's the last paragraph. But if the suit is based on breach of contract, it will not apply. Get me? This was the source of our problem. Why will it not apply? The answer of UP Lucenter was funny but correct. It will not apply. Diligence in the supervision and selection of employee will not apply because their duty is extraordinary, not diligence of a good father. Meron namang mas maganda sagot doon, pero okay na yun. The law does not allow that defense. Okay, are you familiar with the case of Calalas versus Court of Appeals? That's alright. We'll take that up after the break, okay? And together with FGU Insurance versus GP Sarmiento Trucking, for you to understand this well. Okay, I'll see you at 1:59. That's before 2, okay? 1:59. Have a nice lunch. You know, one of the important cases in transportation laws, aside from the pipeline operator case which we took up this morning, remember that? Is the case of Calalas versus Court of Appeals. Citation. You help me check this. Scra. No está, señora. Okay. It's a case decided in May 2000. Maybe 31. But this could be a case that could be both found in commercial law and civil law and remedial law. Now let me summarize this case. This case is about a victim of a vehicular accident, Elisa Sunga. She was a first-year physical education student at the Silliman University at the time. And she rode a jeep going to a part of Negros Occidental from Dumaguete. And the jeepney was full. And typical of provinces, ang mga jeep namumulaklak. Pag puno na, isn't that? Yeah. Have you seen jeepneys in provinces na may nakasakay pati sa hood at pati sa bubong? Yeah, namumulaklak talaga. There is no such thing as overloading. It's only found in Metro Manila. Now, because the jeep was full, she was given an extension seat at the back, a wooden seat, extension seat. Okay? You know the extension seat, yung kahoy, nilalagay sa likod. Yeah, okay. Now, there was a point where someone inside had to stop because someone inside had to get off. And so, the jeep parked to let the passenger inside get off. And because Elisa Sunga was on the way, she had to get down because she was there at the back. She was obstructing human traffic inside the bus. And so she had to get down. When she got down, there was an Isuzu Elf, a truck, that hit the rear of the jeep. And what happened to Elisa Sunga? She was sandwiched in gold-plated quotation marks. And so she was injured. She was hospitalized for 3 months. Poor young girl. Now, the operator of the jeep, when I say operator, the owner of the jeep was Mr. Calalas. So he was the common carrier. Get my point? Okay. And the owner of the Isuzu truck that hit the jeep and caused damage to the jeep and injuries to Elisa Sunga, and the owner was a certain Salva. So Calalas filed an action for damages against Salva under the same facts, alleging that Salva is liable under a quasi-delict as an employer of the driver. You get the point? Okay. So the court decided against Salva, and the court said Calalas is correct. Calalas is entitled to damages from Salva because the negligence of the driver was also the negligence of Calalas, the common carrier, the operator, in negligence in the selection and supervision. Okay. When Elisa Sunga, this case was decided ahead. When Elisa Sunga recovered, later on, she filed a suit against Calalas for breach of contract of carriage. Okay? breach of contract of carriage. You know what the argument of Calalas was? I cannot be liable. I already won in the previous case where the court decided that it was Salva who is liable for the incident, not me. So in the breach of contract suit against him, he said, I am not liable. There is a judgment in my favor in the first case. Now, from remedial terms, can he invoke that case? In other words, he said, it's already a res judicata in my favor. Sunga cannot recover from me because the court already decided in my favor in the quasi-daily case. It's a closed case as far as I'm concerned. It's res judicata already. You know what the Supreme Court said? It's not res judicata as far as Elisa Sunga is concerned. First, the suit was between you and Mr. Salva. And Sunga was not a party to the case. Sunga is not bound by the decision in the quasi-daily case. You follow me? Okay. Second argument of Mr. Calalas. I am not at fault. The proximate cause of the accident was the negligence of the Isuzu truck's driver and the negligence of its employer, Calalas. How did the Supreme Court answer his argument about the proximate cause doctrine? You know what the Supreme Court said? The suit by Elisa Sunga against you is based on breach of contract. Your defense is you are not the proximate cause. That defense of not the proximate cause does not apply in a breach of contract suit. That defense that you are the proximate cause can only be a proper defense in a suit based on a quasi-delict. It's not applicable in the present case. Breach of contract of carriage. Are you fine? Oh, see how beautiful this case is? So a defense of proximate cause is not a defense in a breach of contract suit. In a breach of contract of carriage, it is not a defense. You know what his next argument was? There was no evidence against me that I was negligent in the operation of my jeep. You know what the Supreme Court said? If you were to interpret, you are too much, Mr. Calalas. All your arguments were debunked by this court. And the suit is based on breach of contract against you, and you are insisting that there must be an evidence of negligence? Shame on you. This is a breach of contract suit. Negligence is not an element of this suit. He only has to prove, or she only has to prove, number one, that there is a contract of carriage, and number two, there is a breach of contract of carriage. This is a beautiful case. Now, this is a situation where we involve a common carrier. A common carrier is involved here. What do you think would happen if the carrier involved is a private carrier? You know that in a private carrier situation, there is no presumption of negligence. That the jury is not extraordinary diligence, but one depends upon stipulation. If there is no stipulation or law applicable, then we follow the diligence of a good father of a family, okay? You know what the diligence of a good father is? You'll take that in torch. But just look at me very carefully and silently. Look at me, concentrate on me. Then, you know now what a good father is. It's only a good thing the law did not say a good husband. It says good father. I'm proud of being a good father. See? But take note what the law says, a good father of his family. Singular. It was not plural in the law. The law is a good law. Okay. Now, in one case, a beautiful case, an equally beautiful case, which is often cited by the Supreme Court in its later decisions. I'm talking about this because these are the mothers of decisions on situations like this. There was this case of FGU Insurance versus GP Sarmiento Tracking. The reason I'm mentioning this is because these are the often most quoted cases in recent cases. 386 is correct. Now, this was a case which had its origins in a contract of carriage between Concepcion Industries and GP Sarmiento Trucking. GP Sarmiento Trucking was a trucking company that had an exclusive contract with Concepcion Industries, the makers of Carrier air conditioners and Condura air conditioners and refrigerators. That is not an advertisement. It's the facts. That's the facts of the case. Okay. So one day, by the way, GP Sarmiento Trucking, under its contract, cannot offer its services to the public. Only to Concepcion Industries. Exclusive hauler of its products in its plants in Marikina and other places. And so one day, this GP Sarmiento Trucking was tasked with the duty under its contract to carry to Dagupan City 30 Condura refrigerators. On the way, there was a collision. The truck lied on its belly because of it, and the Condura refrigerators were damaged. And you know, because these guys are businessmen, the refrigerators were actually insured with FGU Insurance. And so FGU Insurance paid the value of the damaged goods to Concepcion Industries. And what happens if FGU Insurance pays Concepcion Industries? It steps into the shoes of Concepcion Industries. Okay? Kung ang dati ay ang Concepcion Industries ang pwedeng magdemanda laban sa GP Sarmiento Trucking, ang pwede nang magdemanda ngayon ay ang FGU Insurance under the subrogatory doctrine or the doctrine of subrogation. So it was an action subrogatoria. Get my point? Okay, so FGU Insurance filed an action to recover the amount it paid to Concepcion Industries. What was the basis of this suit? Breach of contract of carriage. Because if Concepcion Industries would have sued GP Sarmiento for damages, it would have been based under breach of contract because there was an exclusive hauling contract. And so FGU Insurance, having stepped into the shoes of Concepcion Industries, would have to file the same suit kung anong minana niya sa pinanggalingan. The first issue was or arose out of the insistence of FGU Insurance that GP Sarmiento did not exercise the extraordinary diligence required of a common carrier. So the issue became, under the circumstances, was GP Sarmiento Trucking acting as a common carrier? Think about it. Even if it is warm somewhere in where I am right now, I don't think that works. But at the back, I think it's cold. We'll see to it that next time this will be freezing. Okay. The Supreme Court said GP Sarmiento Trucking was not acting as a common carrier because it was not allowed to offer its services to the public under the contract. It had an exclusive hauling contract with Concepcion Industries. It cannot offer its services to the public. So it was acting as a private carrier. So acting as a private carrier, its diligence is not extraordinary. And so GPs are meant to tracking argued, if I am not a common carrier, there is no presumed negligence on my part. And if there is no presumed negligence on my part, because such presumption applies only to a common carrier, then you, Mr. FGU Insurance, should prove my negligence. Correct? The Supreme Court said no. The suit is based on breach of contract. Even if you are a private carrier, there are only two elements of a suit based on breach of contract. Whether you're a public, common, or a private carrier, there are two elements only. First is prove the contract, and second, prove the breach of the contract. Negligence is not an element. Hence, if a private carrier is sued under a breach of contract suit, negligence need not be proven because negligence is not an element. Prove the contract, prove the breach. But if you sue a common carrier for breach of contract of carriage, there are two reasons why you don't have to prove its negligence. First is the all-time favorite presumption of negligence. Second, negligence is not an element. There are two reasons under a common carrier situation why negligence need not be proven. There is only one reason why negligence need not be proven in a private carrier situation. Do we understand each other? I know we do. Okay. Let's talk about the liability of common carriers for damages. Because your syllabus talks about liabilities of common carriers, and this necessarily includes damages. Try to recall in passing your stock knowledge on damages. Moral, exemplary, nominal, temperate, actual, and liquidated. Is there a doubt that a common carrier is liable for the pecuniary loss suffered by the passenger or by the owner of the cargo? There's no doubt. If there is a pecuniary loss, then the common carrier must be liable for it. But that pecuniary loss must be proven. If the pecuniary loss has to be proven, then that damages would refer to actual or compensatory damages. Why should the extent of actual and pecuniary loss be proven? Actual and compensatory. Answer: actual and compensatory damages cannot be presumed. They have to be proven. If you are going to talk about actual or compensatory damages under 2199 of your Civil Code, what does actual or compensatory damages include? Well, it includes not only the actual loss. What does it also include according to your law? It also includes the lost profits. See? The lost profits. Now, would a common carrier be liable for those? Yes, under 2200, the actual loss and the lost profits. Do you remember those concepts? And they have to be proven. They cannot be presumed. Now, what would lost profits comprehend? Would it comprehend the loss of the earning capacity? The answer is yes. Would it comprehend the damage to your commercial standing or your commercial credit? The answer is yes. Because that's very plain under 2205. Those are included in the damages for compensatory damages. Now, maybe if the examiner is at the same time good in civil law, he may also ask you here, what consequences are a common carrier liable for?
aside from asking you whether it's liable for actual or compensatory damages. That's why I would advise you familiarize yourself with 2201 of the Civil Code, because this could be a topic not only here but also in torts and damages. What would be the extent? What consequences would it be liable for? So you go to 2201 of your Civil Code, because in most probability, the bar examiner in transportation law, in commercial law, would actually use a breach of contract suit against a common carrier. Because that's the normal suit against a common carrier, a breach of contract. Although if I were an examiner, I would use quasi-delics at the same time. Okay. Now, look at 2201. Anong extent ng liability niya sa consequences? Madali lang tandaan to kung 2201 ang inyong tingnan, because you're going to distinguish whether the common carrier is in good faith or not. Look, do you see good faith in 2201? If the common carrier in the course of breaching its contract was not really in bad faith, there were no acts of fraud, there were no acts of malice, it was not wanton in its actions, but in good faith. It could only be liable for those consequences which are natural and probable and foreseeable. See, natural, probable, and foreseeable. Do you see those words in 2201? We're simplifying the words. We need not be very technical. But if you are in bad faith, there was fraud, there was malice, the acts were wanton. Oh, you would be liable not only for those natural and probable consequences, but all those which could reasonably flow or be attributed to the act. In other words, all the consequences, whether foreseen or unforeseen. Maybe you should familiarize yourself with these words. But suppose the suit is based on a quasi-delics, You need not make a distinction between good faith or bad faith. It's liable for the consequences, foreseen or unforeseen. Okay. Do you remember exemplary damages? Exemplary damages. Could a carrier be liable for exemplary damages? Yes. In contracts, if the acts of the carrier are proven to be fraudulent, reckless, and wanton, it is liable for exemplary damages. Exemplary damages are those damages that are imposed para yung action mo huwag tularan ng publiko. Dahil grabe sa ating palasak na pananalita, grabe ang ginawa mo at huwag tularan ng pagiging grabe ng iyong ginawa kasi wanton ka, reckless ka, malevolent ka, oppressive ang iyong ginawa. Hindi dapat tularan, kaya pinapatawang ka ng exemplary damages. And when the suit is based on contracts, ang liability mo ay exemplary damages also pag wanton ang acts mo. Okay? Now suppose you are sued on a quasi-delict. When can you be liable for exemplary damages? Answer, if your acts constitute gross negligence. That could be 2231 already. The first thing I mentioned was 2232. Did you see it? Okay. If you did not see it, never mind. Now, take note of this. Kung pinatawan ng common carrier ng exemplary damages, papatawan din siya ng attorney's fees by way of damages, kasi may attorney's fees by way of damages. 2208, number 1. Number 1. Kung ang kilala ko ang gagawing examiner, itatanong ko ang hilig nun sa damages sa commercial law. Kaya tinatalakay ko ito, baka siya maging examiner. Don't look at me that way. I won't reveal his name. I have a vow of secrecy. I will only talk about what he likes. Is it possible for a common carrier to be liable for liquidated damages? By the way, what are liquidated damages? Could you look at 2226 of your civil code? I'm not sure, but it might be 2226. Liquidated damages, those agreed upon by the parties to a contract to be paid in case of breach. Is it? Yes, 2226. Now, are common carriers also liable for liquidated damages? Yes, depending upon the terms of the bill of lading or the ticket of the passenger. And the liquidated damages portion here would fall under 1749 of your law on common carriers. 1749. Look at 1749. Always asked in the bar. At least in the 80s, with a sprinkling in recent years. Is it possible for the carrier to state as part of its stipulation that the common carrier's liability is limited to the value of the goods appearing in the bill of lading, unless the shipper or owner declares a greater value? Yes, it is. It is. It is. And it could be binding. Remember this, it could be binding if the passenger or shipper or owner of the goods is given the right to declare a higher value. Did you see the words, unless the shipper or owner declares a greater value? That is what will make the stipulation valid. If there is no such proviso or proviso, the stipulation is not valid. And there are several bar questions in that, but let me tell you the doctrine first. Let us suppose the ticket says, or the bill of lading says, the carrier shall be liable for only 500 pesos per baggage. Is that valid? The answer is no. It does not give the passenger or owner of the goods the right to declare a higher value. It's not binding. You follow me? Okay. The liability of the carrier will only be 1,000 per baggage, irrespective of the value. Valid? No, that's pernicious. You know what pernicious means? That's evil. Mas grabe sa unang stipulation. That's oppressive. The carrier shall be liable only for 1,000 pesos per baggage, but he may declare a higher value and pay a higher freight. Valid? Yes. That's the valid stipulation. Give the shipper or owner the right to declare a higher value. You know, the most famous case on this was not the famous case, the most famous bar examination on this was the case using the words Doña Buding. When I was younger, emphasis on the word younger, Doña Buding was a comedian, and her name was Nanette Inventor, yes. Does she appear yet? I don't know. And she was used in the 1985 bar exams. Doña Buding. This is the famous one, Doña Buding. Do you have your exams? Yeah, it's 1985. Just look for the number iyo. Matagal hanapin. Number 4 muna, tingnan mo. Para mas malapit sa number 1, number 4. Doña Buding. It's a beautiful bar exams, and that has been used as the models in subsequent exams. That's why I won't lose the opportunity. I don't want to lose the opportunity of reading it to you because it's the model of other exams. The Doña Buding bar exams. You know, I just forgot who the examiner was at the time. Wala ba? Number 4, subukan mo. Kung hindi natin makita, saka na natin hanapin. Number 4 ba? Okay, halika. Pabasa. Kung hindi natin makita, bukas na. Walang klase bukas eh. Okay. Ano ba salamin ko? Wala. Sige, apohapin ko na lang. Okay? Kasi wala kang salamin. Oh, malabo talaga. Okay, never mind. Doña Buding checked in at the Philippine Airlines counter of the Manila Domestic Airport on a flight to Bacolod. Noticing that Doña Buding has 2 big baggages being checked in, dalawang big baggages. Sabi ng counter clerk, the counter clerk called her attention to the stipulation in the plane ticket and asked if she was going to make any declaration of the value of the same. But Doña Buding just looked at him and did not say anything. Imagine Doña Buding not talking with a smirk on her face. Okay. The plane arrived in Bacolod, but the 2 baggages could nowhere be found. Pal promised to deliver the 2 baggages the next day, but it never did. Doña Buding is now suing Pal, claiming 10,000 damages for the loss of the 2 baggages. Pal answered that it was liable only for 200 pesos because the plane ticket clearly stipulated that the total liability of the carrier for lost or damaged baggage is limited to 100 pesos per baggage unless the passenger declares a higher valuation in excess of 100, etc., etc. The trial court ruled in favor of Pal and against Doña Buds. Okay. Comment on the legality of the court's decision. Here is the answer of the UP Law Center. The ruling of the trial court against Doña Buding is legal, being in accordance with the new Civil Code and Common Carriers. A stipulation that the common carrier's liability is limited to the value of the goods appearing in the bill of lading unless the shipper or owner declares a greater value is binding. Take note of that model question. Okay, thank you. Oh, there are many other questions. One question was a simple essay. I don't know if that one has 1998. I remember a question there in number 2 in 1998, but it's not as beautiful as Doña Buding. Also, the emphasis was on unless the shipper or owner declares a higher value. Is it? Number 2? Yes, it's number 2. Not number 1. Okay, let's read this one. You know this. It's very easy to answer this. By the way, do not take the bar exams without reading this, especially in commercial. You know why? Commercial law's questions and essays are normally duplicated. They only say it in different words. In some bar exams, the words are exact. Because commercial law examiners do not want to commit mistakes. But remedial law, they're so reckless, they will ask any question. But commercial law, they're very cautious. The utmost diligence of very cautious persons. That's 1755. Here, yeah, yes, this was a case. I'm sorry, this was a case. Iba pala yung nasa isip kong hindi case sa 2000 ko pala yun. So this is simply Doña Buding also, but this is very long. Ganun din. Basahin ko naman. X took a plane, a seaplane, Doña Buding, from Manila bound for Davao. Well, this time it's Davao. Sumawa na sa Bacolod. Via Cebu, where there was a change of lanes. Try to answer this on your own. X arrived in Davao safely, but to his dismay, his 2 suitcases were left behind in Cebu. The airline company assured X that the suitcases would come to the next flight, but they never did. You see that? They copy heist the old bar exams. X claimed 2,000 for the loss of both suitcases, but the airline was willing to pay only 500 pesos because the airline ticket stipulated that unless a higher value was declared, any claim for loss cannot exceed 250 pesos for each piece of baggage. X, however, reasoned out that he did not sign the stipulation, and in fact, he did not even read it. X did not declare a higher value despite the fact that the clerk had called his attention to the stipulation that in the ticket that he could declare a higher value. See, this is Doña Buding. The answer is the same. He did not declare a higher value. Then the carrier will be bound for this only by the stipulation. Okay? There are many cases, pero nakakatamad ng basahin. But the same is the story. The same refrain. So remember the words, unless it declares a higher value. But look, it is his fault that he did not read it. But if he could not read it, that's a different story. Kung nababasa naman, hindi mo binasa, you are free to reject it. Sure, it's a contract of adhesion. But a contract of adhesion is not inherently bad because you are free to reject it. But if you cannot read it because the letters are so microscopic and extremely Lilliputian, 1750 will come in. Look at 1750. That means it was not fairly and freely agreed upon because it could not be read. It could not be read. Get my point? Because 1749 also requires that the stipulation must have been freely and fairly agreed upon. Kung hindi mabasa, saan ang fairness doon? Saan ang freely agreed upon? Tingnan mo nga ang 2002 number 9. Mukhang may tanong dyan. 2002 number 9. There are two questions in that number 9. But let's read only the second question. This I don't think it was a case problem. It was simply an essay 1. You were asked about the validity of the stipulation in this question. This was one of the last questions on this topic. See? Matagal nang hindi na itatanong. Listen to this. You are going to decide whether the stipulation is valid. The stipulation is, yes. Okay, a stipulation that in the event of loss, destruction, or deterioration, the carrier's liability is limited to the value of the goods appearing on the bill of lading unless the shipper or owner declares a higher value. Is this valid? 5 points. It is valid because it gives you the right to declare a higher value. See, that's the key word there. It should be there unless the shipper is allowed to declare a higher value. That would make the stipulation valid. If there is no such proviso, it's void. Lalo na pag sinabing, liable only 500 whatever happens, even if this world sinks. No. Kasi walang option to declare a higher value. Get my point? Now, let me ask you one thing. Is it possible for a common carrier to be liable for moral damages? Liquidated damages, yes. Exemplary damages, yes. Actual compensatory damages, yes. But you have to prove it. If you cannot prove it, ipapataw sa'yo nominal. Okay? Kasi hindi mo na-prove. Kasi once there is a violation of a right, nominal damages will come in whether you prove it or not. But it's not as great as actual or compensatory, which have to be proven or which has to be proven. Now let me ask you, can a common carrier be liable for moral damages? Let's try to review your CV law, okay? I see some pins here. What were these for? Oh, for the mark. Moral damages, 2217. Is it? Sige nga, tingnan natin. What are those injuries for which one is liable for moral damages? Physical suffering, is that it? Mental anguish, fright, serious anxiety, besmirched reputation. Is that right? Wounded feelings, nasugatang damdamin, besmirched reputation, naputikang karangalan, moral shock, social humiliation, and similar injury. Okay, here is a passenger. A passenger was seated at the back of the driver. Then the driver was a reckless driver, running 100 kilometers per hour in a 70 kilometer per hour zone or 60 kilometer per hour zone. Then black, in a split second, an accident. It hit the cemented portion of the island and it turned turtle. The passenger was severely injured. His nose went to his forehead. His right ear went to his left cheek. His left ear went to his right cheek. And his lips went to his chin. And his chin was nowhere to be found. And he healed. And after that, he could no longer distinguish whether he is terrestrial or extraterrestrial, whether he is a vertebrate or an invertebrate, whether he is warm-blooded or cold-blooded, undistinguishable. So he suffered from pain, so physical suffering. He suffered from humiliation, wounded feelings, and his reputation, according to him, was severely besmirched. He sued the common carrier for breach of contract of carriage. He proved all his injuries. The court did not give him moral damages, but actual and compensatory damages. Do you think the court is correct? Sabi niya, hindi ko na nga alam kung tao pa ako hindi. Tapos wala pa akong moral damages. Sama ng loob niya. Pinipilit ibalik yung kanyang ilong, ilagay sa dating kalagyan ay dumikit na, nag-heal na. Paano yun? Kasi, mga kaibigan, sa pag-analyze nyo ng damages, moral damages, kailangang bigyan nyo ring pansin ang 2219. May mga specific cases kung saan ka makakahingi ng moral damages. Hindi nangangahulugan na kapag ikaw ay nagkaroon ng physical suffering, mental anguish, besmirched reputation, fright, serious anxiety, wounded feelings, moral shock, social humiliation, and similar injury, ay makakahingi ka na karaka-raka at automatically ng moral damages. Kailangan tingnan mo rin ang kaso laban sa defendant. You can only ask for moral damages in relation to 2217 in accordance with 2219. Do you notice? Breach of contract is not one of those cases. I hope you notice it. Breach of contract is not one of those cases. What are those cases? Criminal offense resulting in physical injuries, is it not? Quasi-delicts causing physical injuries. Seduction, abduction, rape, and other lascivious acts, right? Adultery, concubinage, illegal or arbitrary detention or arrest, correct? Illegal search, slander, libel, and other forms of defamation. Is it there? Am I correct? Yes. You also have malicious prosecution. Then you have acts mentioned in Article 309, and those acts are interference with funerals and disrespect for the dead. You also have acts mentioned in Article 21, right? Please help me. My memory cannot be trusted. 26, 27, 28, 29, 30, and 32, 34, 35, right? Okay. Those are the cases where you could ask for moral damages. A breach of contract suit is not found there. The court is correct. No moral damages. So if you want to ask for moral damages, you have to prove the existence of 2220 if your suit is based on breach of contract. You have to prove that the common carrier breached its contract through fraud or bad faith. Then you can ask for moral damages. Did you see fraud? Did you see bad faith in 2220? Come on, tell me. Yeah, then. So, where the common carrier has not been shown to have been in bad faith and to have not committed fraud in the performance of its obligation, you can ask for other damages, but no moral damages. You cannot even ask for exemplary damages, because exemplary damages would require a wanton act, an oppressive act, is it not? Yeah. If it is in good faith, then it will be liable only for those natural and probable consequences of acts and those which are foreseen reasonably foreseen. Is there any other instance when you can ask for moral damages against a common carrier, even if your suit is based on contracts aside from bad faith and fraud? Is there any? Yes. If there is death, the passenger dies. But I don't think it's found in 2220. It could probably be found in, give me a little time to recall, okay? Article 2206. You go to number 3 of that and it could be there probably. 2206, number 3. There is death. The spouse and the children could ask. Now let me try to check my civil code here. It has been lying here since this morning. I have not opened it this afternoon. I just want to check 2206 because I'm not even sure about the provision. If you saw it already, tell me so that I'll not be opening this. Never mind, I'll open it anyway. The spouse, legitimate and illegitimate descendants and ascendants of the deceased may demand moral damages for mental anguish by reason of the death of the deceased. Okay, so that's moral damages. So, can there be liquidated damages? Yes. Now let's talk about bad faith. How could a common carrier be guilty of bad faith? Well, not really the common carrier, because the common carrier, if it is a corporation, is a fictitious person, okay? But through its employees. Have you read the case of Japan Airlines versus Simangan? Did you study this? Because you're new graduates, most of you, and this was in 552 Scrum. You know, this guy, Mr. Simangan, has a relative in Los Angeles. And his relative in Los Angeles was suffering from a severe kidney disease. And then they were looking for a donor, a kidney donor. And Mr. Simangan was the right person. He was actually examined in the Philippines, and the results of the examination were sent to UCLA, and the UCLA doctor said it was a perfect match. And so, UCLA Hospital, because UCLA is a university, but it has also a hospital, like University of Santo Tomas, which has a hospital. And the officers of UCLA made representations to the local U.S. Embassy to give him a U.S. visa. They called it a humanitarian visa. And so, he boarded Japan Airlines to Los Angeles, here in Manila. At that time, Japan Airlines was here. I don't know if we still have Japan Airlines here right now. And so it was via Narita, Japan, where even the Philippine Airlines make stopover sometimes. You know, when he boarded the plane, the stewards and the stewardesses, simply by looking at him, suspected that he was not really truly going to Los Angeles. That he was going to disembark when the plane reaches Narita, Japan. And he was accused of having fake documents. And he was rudely asked to step out of the plane and to go to the US Embassy and get a certification that his papers were actually valid. And he pleaded to them and explained his case. But they rudely asked him to vacate his seat and get off and go to the US Embassy, which he could not because the plane was leaving in an hour. He was left. The following day, however, he was asked to board the plane. He sued for breach of contract. The issue is, could he be entitled to moral damages? Yes. He was rudely bumped off the plane. They never showed respect to him. There was bad faith, according to the Supreme Court. Moral damages was proper under the circumstances. Did you study this in your undergraduate level? And there was this also beautiful case of Singapore Airlines versus Fernandez. It could be 417 scrap. This was about a famous soprano. Fernandez is famous in the Philippines and abroad. She's a lady. But at that time, she was in Germany pursuing a master's degree in music. And she was invited by the Queen and King of Malaysia to perform before them. So they procured a ticket for her from Germany to Manila and from Manila to Malaysia via Singapore Airlines. You know, then she boarded Singapore Airlines in Germany, going to Singapore first. Singapore, Manila. And when they reached in Singapore, the connecting flight from Singapore to Manila had already left. Because he was to go to Manila, then from Manila, Malaysia. And she explained her predicament to the counter clerks of Singapore Airlines. Hindi siya pinakinggan. She was even insulted. And she was insulted so severely because artists are so sensitive, and she was so sensitive. She could not buy her own ticket. She had no money. So her relatives in Manila had to send her money in Singapore where she was stranded. And for 2 days, she went to Singapore Airlines to ask for help. Walang pumansin sa kanya. Binigyan lang siya ng ticket nang may pera siya. You follow me? At ang interval lang naman ay ilang minuto, lumipad aeroplano, hindi na lang siya hinintay, may connecting flight. Magaling naman dyan ang Philippine Airlines sa paghihintay, sa sobrang paghihintay, sobrang delay. Okay. So, nakarating din siya sa Malaysia. But because he was emotionally upset, her performance was not at par. It was below par. Then she sued. She was asking for moral damages. Was he awarded moral damages? Yes. Bad faith. There was no good faith in the airlines. But I know your most famous case was Air France versus Carrascosa. That's more familiar to you. The antique cases, they're more familiar to you. Remember Air France versus Carrascosa? See, that is one of the early cases where the Supreme Court said, even if the parties are bound by a contractual relation, yet the act that breaks the contract may be a tort. And you could sue the carrier based on a tort. However, it was misinterpreted to be sued under a quasi-delict. You know why? Because a tort is not necessarily a quasi-delict. A quasi-delict is a tort. But not all torts are quasi-delicts. Why? Because in relation to transportation laws, let me tell you, there are 3 kinds of torts. Intentional torts. Number 2, unintentional torts. Number 3, strict liability torts. In intentional torts, you have to prove the intent. In unintentional torts, you don't prove the intent because it is unintentional. Prove the negligence. Unintentional torts are negligent torts. That is where a quasi-delict comes in. How about strict liability torts, sir? Oh, you don't have to prove intent. You don't have to prove negligence. The fact that the injury happened, you are liable. Is that so, sir? Yeah. Yeah. There are 2 strict liability torts under quasi-delicts. Under the provisions, dalawang nasingit. One is 2183 and one is 2193. I hope you studied that before. Liability for animals. And 2193, those falling from buildings. Is that it? Could you help me? Okay, Air France versus Carrascoso. Mr. Carrascoso took a ticket from Manila to Rome. Manila to Rome. Stopover in Bangkok. What happened at Bangkok? He was taken out of his seat in favor of a white man. Bad faith. Could he ask for moral damages? Yes. You studied that. Air France versus Carrascoso, yes? Yes. The doctrine is, even if there is a contractual relation between the parties, you could sue the airline based on tort because the act that breaks the contract is a tort. Did you remember that? Oh, but there is a more beautiful case, an old case. Sulweta versus Pan American Airways. Sino nakaabot na ng Pan American Airways na aeroplano? No. You were very young. This was the sikat airplane when we were young. Pan American Airways. Saan ka sumakay? Pan Am. Wow, sikat ka pala. Saan ka sumakay? PAL. Hindi sikat. Saan ka pumunta? Sa Los Angeles. Ano sinakyan mo? PAL. Pag sinabi mo, Pan Am. Wow. The Sulweta family had a vacation. They came from Hawaii, Honolulu, Hawaii. They went to Manila. The stopover was Wake Island. Wake Island in the Pacific. Okay. So from Wake Island, we were going to Manila. And they made the stopover. Sabi ng intercom, we have 30 minutes stopover, etc., etc. Eh, nag-jingle si Mr. Sulweta. Hindi naman siya maka-jingle sa plane, mahaba ang pila. Bumaba siya sa terminal. Pagdating niya sa terminal, sa Boys CR, hindi siya maka-jingle. Bakit? Nakapila ang maraming mga sundalong Amerikano. At he was dwarfed by the big Americans. So ang ginawa niya, pumunta siya sa may beach. Doon siya naghahanap ng place to answer the call of nature. It was urgent. Eh sa dami ng tao sa beach, hindi siya makahanap. Kasi mahiyain siya. Okay. So, sa tagal niyang makahanap, pagbalik niya ng aeroplano, lagpas na ng 30 minutes. At ang, ano lang naman, ay mga 5 minutes. He was berated, pinagalitan, bumaba pa ang piloto, pinagalitan siya. Ang mga crew members, pinagalitan siya. You are a monkey! Duminggi lang siya, naging monkey pa. Alam mo ginawa? Iniwan siya ng aeroplano, sinadya, ay nandun na siya. Iniwan siya. Iwan siyang pera. So, pinadalan po siya ng pamilya niya. Ang pamilya na iwan sa airplane. Yung dalawang anak na kasama, hagulgul na hagulgul. Ang tatay nila na naging monkey na iwan. Kawawa naman yung pamilyang yun. He was left in Wake Island. Now, was there bad faith? Of course, yes. Was he able to ask for moral damages? Yeah, the answer is yes. Yun ang kasong 43 iskra na matatawa ka. Wawa naman yung tao. Siguro nagka-trauma yun. There was another case, Lopez versus Pan Am, also Pan American Airlines. Are you familiar about the name Fernando Lopez? He used to be the Vice President of the Philippines during the time of the first term of President Marcos. Fernando Lopez from Iloilo in 16th Pra. Okay. Vice President Lopez had first-class reservations with Pan Am. Why first class? He's very rich. From Tokyo to San Francisco. Yun pala, kinancel ang first-class reservation niya without notifying him. Without notifying him. Eh wala naman siyang reservation sa tinatawag na tourist class. Ang tourist class ay economy class. You see the name? Beautiful name. Go to PAL and you go abroad. The economy class is called Fiesta class. Wow, fiesta. Ang sikip. Ang sikip ng paa mo. Pupunta ka sa Los Angeles, halos 14 to 15 hours. Pagkatapos si Fiesta class ang tawag, titingnan mo na, Fiesta class. Siguro may fiesta dito, may bibingka pa rito. Hindi. Magkakaroon ka ng cramps. And so, it was cancelled. Sabi ng Supreme Court, if it was cancelled, he should have been notified by it. He was not notified. Doon na lang sinabi, pagdating sa airport, cancelled na. So, nakasakay din siya, kinabukasan na, tourist class. Ganda ng pangalan, tourist class. Hindi bagay sa Vice President, tourist class. So, remember, if you sue the airlines for breach of contract, what should you show? Fraud, bad faith, or death if you want to recover moral damages. Without such showing, you cannot recover moral damages. Okay. Tuloy-tuloy ang lecture, yung pala, natalakay na natin yung itatanong sa bar. When does the contract of carriage begin? That's a part of your syllabus. Let's go to goods first. You go to 1736. If it is really 1736, let me check. That with respect to goods is when the contract of carriage begins. When does it begin? When the goods are unconditionally placed in the hands of the carrier, received by it for transportation. Okay? Until the consignee receives it either actually or constructively, or has been given a reasonable time to remove it or dispose of it. Right? Okay. Suppose during the course of the voyage, in a port of call, at the middle of the trip, the goods are unloaded for some valid reason and stored in the warehouse of the carrier. Does the contract of carriage still continue? Yes, because it has not yet reached its destination. Unless the shipper exercises his right of stoppage in transito, which means he will take control of the goods. That's 1737. Now, and what kind of diligence is required here, as we mentioned? Extraordinary diligence. Yes. Now, with respect to passengers, maybe you try to recall the case of Dangwa Transportation versus CA. Have you tried? Have you taken that up? I think you did. The only thing is we don't remember that now. But it was a case on October 7, 1991. I do not even remember the scra. What is in my memory is the date. October 7, 1991. Dangwa Transportation versus Court of Appeals. This will give us an idea and demonstrate to us when carriage of passenger begins. This guy actually was waiting in a street corner. Then the Dangwa bus arrived. Then, because it is our common practice, we made a motion for it to stop. Get it? That's what we do. And it will slow down. It slowed down. And the guy, the passenger, stepped on the running board on the platform. But it accelerated. And the guy who did not have strong limbs, as normal people do have, fell from the platform. And he was crushed by the rear wheels of the bus. What happened? Use your imagination. He died. The argument of Dangwa, he was not yet inside the bus. So he is not yet a passenger. The Supreme Court said he was already a passenger. It already began. He already stepped on the platform. He already stepped on the running board. Have you come across the Navidad case? And that involved LRTA, Light Railway Transit Administration versus Navidad. That's 397 Scra. It's not really a new case. 397, so that could be 2003. You know, this guy, Navidad, bought, it's not a ticket, what do you call that? The coins? A token from EDSA LRT. And he entered the premises, he was drunk. And he had an altercation with the guard. It was not very clear, and they fought. There was fisticuffs. It was not very clear, however, in this graph, who delivered the first blow. But what was clear was that while they were boxing and hitting each other, Navidad fell on the tracks. And right after it fell on the tracks, here came a train zooming, crushing him to death. Moral lesson, do not go there if you are drunk. The question is, could there be a breach of contract suit even if he was only in the premises of LRTA and he was not yet on board? The Supreme Court said there was already a contract of carriage. While this is somewhat controversial, the other lawyer actually said beautifully, there was only a contract to carry at the time. There was yet no actual contract of carriage. But the Supreme Court said he was there in the premises as preliminary step to board. The carrier should have took care of him with extraordinary diligence. The duty of the common carrier extends not only to actual presence in the equipment of the common carrier, but within the premises where he is ready to board. It already began, the contract of carriage. I'm not sure, Iho, do you have 2008 there? He is short of 1 year. His copy is up to 2007. And I am telling you, this was the case that was exactly used in the 2008 bar exams. It was in number 8. Instead of using LRTA, they used City Railways Incorporated. All the facts, including the fact that the deceased was drunk, etc., etc. You know, I'm hoping that they will ask what case we were talking about the pipeline operator case. First Philippine Industrial Corporation versus Court of Appeals, 300 SRA. Yes, I hope it would be asked. I also want and hope that they would ask something about Meralco, whether it is a common carrier. Yes, it's a regulated common carrier. Now, there are times I do not join answering these mercantile law bar exams because every time they have a meeting, most of the time, we have a pre-week and remedial law. Di ba magkasunod yung mga subjects na yan? I think I was with them in 2009 and 2005, etc. And when we answer bar exams, we normally quarrel. You know why? Even in remedial law, we quarrel. Because my position is always this: the answers that we should give are answers from the point of view of new lawyers, not from your point of view who are seasoned lawyers already. And the answers you want to suggest, I always tell them, are answers that are so deep, so profound. That is not the purpose of the bar exams. Then I would add some words: shame on us. Not on you, okay? Shame on us. Our answers should be the normal answers given by a senior law student, not of a seasoned litigator. We will be unfair. With me in that belief is Dean Sandiang, Dean Abelio. The others are so deep. Yeah, it's correct, but it should not be deep. And the examiners follow the answers of the UP Law Center. It's like this: etong aming sagot, para bang kahit hindi sinasabi, para ganito, sundin mo yan. May persuasive effect yan sa examiner. Ngayon, pag hindi kami nagkakaigi, sabi ko, maglagay kayo ng alternative answer. Naglalagay naman. Ngayon, may nakita akong mga sagot niyo sa mock bar, ang hahaba ng sagot. Huwag ganun sa actual bar. Pag natumbok niyo na ang sagot, tumigil ka na, uy. Masyado kayong madadagdag. Huwag ka nang maghanap ng second page. Doon ka na lang. Ganito, an affidavit of self-adjudication under the rules will only be proper where there is no will. But the facts of the case indicate that there is a will. Huwag nang habaan pa. The action is not therefore in accordance with existing procedural rules. O, tapos, ganun. Hindi ka pagtsatsaga ang basahan ng checker. Get it from me. Because I talk to them. Kasabihin nung iba, kadalasan yan, mabuti kung kasing bata ko yung checker. Kadalasan at mabuti kung ang mga checker ay gaya kong pasensyosong magbasa. Ay sus, lalo na pag mga matatanda, may edad. Pag mahaba masyado yan, hindi ka babasahan yan. At huwag niyong itago ang inyong konklusyon. So, umpisa pa lang, sabihan mo na. Dahil yun ang kanyang hinahanap. Huwag masyadong mahaba. Kasi, you are not writing a thesis. You're answering a bar exams. May mahaba. Kailangang mabigyan ng comments, huwag mahaba ang sagot. Ako ba ay tao? Sagot, ako ay tao. Isang kinikilalang alituntun ay tao may dugo, may laman at marunong kumindat. Ako'y may dugo, may laman at marunong kumindat, kaya ako'y tao. Tapos, huwag masyadong mahaba. Kahit gaano kaganda or scholarly, it will not be appreciated because of its length. You get my point? Okay. You know, your syllabus makes distinction between safety of passengers, vigilance over the goods. We cannot do anything about it, so we talk about it. Safety of passengers. Okay, look at 1755, the basic rules on safety of passenger. We're going to give another rundown of this just very briefly. You look at 1755, utmost diligence of very cautious persons. Okay? Utmost diligence. Biro mo yan, utmost diligence na. Meron pang dagdag of very cautious persons. Paano ma-define yan actually? Paano magamit yan? May utmost diligence ka ba? Oo, kulang. Very cautious ka ba? Biro mo, tatanungin ka ba? If you're going to be very technical about it, it's very difficult to apply it in actual practice. Okay, you go to 1757 for a while and see the rule. It cannot be dispensed with by stipulations, is it not? Notices and so forth and so on. But it can be lessened with respect to passengers that are gratuitously carried. Is that correct? Yes, there could be a stipulation. But go over it again. Reduction in fare does not justify any limitation, okay, of the carrier's liability. But take note, it applies only to passengers. If you are not a passenger, you are not covered by that protection. Sir, how do you know he is a passenger or not? Loko rin ng examiner. Tignan mo nga 1989. May lokong examiner dyan. 1989. 1989, may tren, may kinargang palay. 89, number 12. Tingnan mo nga na. Kinargang palay. Tingnan nyo. Alam nyo ba na tinanong yan 1989? Inulit yan 20 years after? Ituro mo nga anak. Okay. X brought 7 sacks of palay to the PNR. What's PNR? Philippine National Railways. He paid each freight charges and was issued way bill number 1. The cargo was loaded on the freight wagon of the train. So, sa kargahan ng freight. Sa bagul. Without any permission, si X, na may-ari ng palay, boarded the freight wagon and he did not go to the passenger coach. So, gustong sumakay ng libre. So, doon siya nagtago sa bagol ng mga cargo, hindi sa passenger side. Shortly after the train started, it was derailed. Kawawa naman tao ito. Nangiinubo lang, na-derail pa. The freight wagon fell on its side. God, this is killing me. Killing X. Hiro mo na, matay siya. There is no evidence that X bought a ticket or paid his fare at the same time that he paid the freight charges for his cargo. Is X a passenger of PNR? Answer? No. X was not a passenger. He is a stowaway. A stowaway, being a trespasser, has been held to assume the risk of damage. He is not a passenger. Okay? Stowaway. Have you tried doing this stowaway? Oh, I tried it. I was a young boy. Ako'y napalo ng tatay ko. I was 11 years old. Tamang-tama, I was visiting him in Romblon. And I was enrolled at that time, briefly at Letran in the elementary grades. Because they would send me anywhere. And I had a vacation. He hit me with yanto. And I cried. And then I went to the pier and I saw that the ship was about to leave. And I jumped inside. And I saw friends who were going to Manila. Sabi, sakay ka na. Wala akong damit. Sakay ka lang. Bigyan kita ng damit. Ayun na po. Naghahanap na ng ticket. Wala akong ticket. Wala akong pera. Nang kinapa ko ang aking short pants, meron ako 25 cents. Sabi naman, bigyan mo ako ng pera. Sabi ko doon, bibili rin ako ng ticket. Ayaw naman akong bigyan. Sabi sa akin nung nanay nung kaibigan, magtago ka na lang. Walang yun, first class, tiheras lang na nakalinya. Kaya kung andito ang tagatago ng ticket, sa ilalim ako ng tiheras dito. Pagdating niya dito, crawl naman ako papunta sa kabila. Dino mo, nung mabasa kong bar exams nito, pag nalumog pala yun stowaway ako. Pagdating ko rito sa Maynila, sa Pier 4, sabi nung kaibigan, saan ka nakatira? Dito. Sa Dimasalam. Tawag ako sa auntie ko, andito ako. Kasama mong daddy mo, hindi ako lang. Pagdating ko, ano bang nangyari sa iyo at nakasando ka lang? Nakachinelas ako. Yung uso nun ay beach walk na chinelas goma. Pero wala na ang kaliwang paa. Dahil hindi ko na makita kung saan. Anong nangyari sa iyo? Matagal pa ang klase Opo, pinalo ako. Ito po ang latay ko. Nasaan damit mo? Wala po. Anong ginawa mo? Sumakay lang sa bangko. Nice experience. Nice experience. Because I was a naughty boy. Alam niyo kung bakit ako pinalo? Binato ko ang bintana na salamin ng mayor. Okay. Now, itong stowaway, I know was repeated 20 years ago in the 2009 bar exams. It was repeated. Wala tayong 2009. Sinong meron 2009 dyan, pahiram? Wala? Kasi sabi sa akin ng mga naka-attend dito, hindi ako naka-attend dito Kasi nag-pre-week ako ng remedial law Nagkaroon ng malaking discussions dito. Hindi sa stowaway. Imagine 20 years after, inulit yung stowaway. That's why I advise you to read old bar exams. 1989, 2009, ilang years yan? Di ba 20 years yan? See? Yung mga pumasa nung 1989 na kumuha niyan baka yung anak nila ang kumuha ngayon ng stowaway. See? Merong pagtatalo daw sila dun. Ang pagtatalo sila sa kanila ay ganito. Kung passenger, yung isang nakasakay sa bus na nang-hold up, hinold up yung katabi. So, ang discussion nila sa UP Law Center, ayon sa bar exams, kinuwento ito ng dalawang nandun Sabi, ba't hindi ka umatid? Hindi pwede. Alam mo ba may pagtatalo rito? Sumakay sa bus yung hold up Tapos pagdating doon, nang-hold up. Ang nanalo sa discussion ay yung grupo na nagsasabing hindi siya passenger. Dahil ang passenger daw ay yung tao na nagpapatransport from one place to another. Siya nagpapatransport para mang-hold up. Pero kung nandun ako, igigiit ko yung sagot na passenger din siya. Kasi nagpapatransport siya from one place to the other. Hindi ba passenger yun? Ibig sabihin, passenger ka lang kung ang purpose mo ay legitimate. Follow me? Oh. So nanalo yung hindi raw passenger dahil hindi raw yun ang definition ng passenger sa American law. Kaya nga wala na tayong 2009 bar dito eh. Yung isa pa, nagtatalo. Yung driver, may kabit. At yung kabit, laging nakakabit. Habang nagdadrive ng bus, nandun sa gilid niya. Bakit? Para sumama doon sa driver na kinakabitan. Dahil pag may kabit, may kinakabitan. Na-disgrasya. Ang discussion daw, passenger daw ba? Ang nanalo ay hindi passenger. Pero kung akong tatanungin, hindi ba passenger yun? Kasi pinulot mo dito at pupunta ka doon. Yung nanalo, sabi ko, tawa ako ng tawa, masyado namang immaculate ang puso. Pwede ka naman passenger kahit masamang tao ka. Okay, yung isa is stowaway. Yung isa naman, kung passenger yung may free pass to ride. Well, passenger yun. Isa na? Passenger. Pero yung nang-hold up, hindi ba passenger? Kaya na nga siya naging passenger, gusto niyang mang-hold up. So, ang suggestion nila, titingnan na lang ang reasoning ng examinee. Kaya lang, they had to make a stand. Kaya lang, the others accepted the answer with a grain of salt. It's always like that at the UP Law Center. But after that, you shake hands and you eat together and you forget the heated discussion. It's a beautiful place to be. I was not able to join them in remedial law last year. I had a more important thing to do. Okay, I am a passenger. I had an altercation with the conductor. You know what the conductor did to me? Remember yung ginagamit niya sa pagbutas ng ticket? Binutas ang tenga ko. And he hit me, pa! And I was something. Then I fell to the pavement, crying, cold, and almost dead. I sued the common carrier for the willful acts of the conductor. The defense of the common carrier, he went beyond his authority. He had no authorized to put a hole on your ear. He was not authorized to hit you. He was not authorized to wound you. The question is the common carrier liable for the willful acts of the conductor even if he acted beyond his authority? You go to 1759. That is seldom asked in the bar. I remember it only being asked once. This is about death or injuries caused by the employee of the carrier. By what acts? Willful acts or negligent acts. And even if he acted without authority. Right? Okay. Or against the instructions of or orders of the carrier. Okay. I am a passenger. I was seated beside the passenger, and the passenger simply did not look at the way I looked at him, and he got a knife and stabbed me on the chest. But I survived, of course, because I belong to a different breed of grass. How would you analyze the liability of the common carrier under the circumstances? When will the common carrier be liable? You look at 1763, because that will be the test of liability. Then you will ask, were the employees of the carrier able to prevent or stop the act? Had they exercised diligence of a good father? Had they exercised such diligence, had they been able to stop it? If the answer is yes, the carrier is liable. If they were not able to stop it despite diligence, the carrier is not liable. Is that 1763? Could you check it for me? Yeah. Okay. Your first break is 3:30. It's 3:31 and 15 seconds. So I will be back in a short while, okay? Let's go out. And I was told I'll be back on Thursday. Yes, because on Thursday we'll talk about maritime commerce and Warsaw Convention. You don't want to leave? Okay, I will. You're waiting for me. Thank you for your courtesy. To designated loading and unloading facilities to board the train. Ricardo Santos purchased the ticket from Calamba and entered the station. While waiting, he had an altercation with the security guard of CRI, leading to a fist fight. What case is this? Navidad, see that this is an exact reproduction of the case. And this is one of the characteristics of commercial law exams. They use a lot of cases. In the action for damages filed by the heirs of Ricardo Santos, CRI or City Railways Incorporated interposed lack of a cause of action, contending that the mishap occurred before Ricardo Santos boarded the train. Do you agree with CRI? You don't agree with CRI. He is already a passenger. The extraordinary diligence already applies. By the way, you have in your provisions on common carriers a provision on contributory negligence. And you have two provisions there. 1741 and 1762. 1741 would be in relation to goods. Could you check it for me, okay? And 1762 is in relation to passengers. Is it right? Yes. Those embody the doctrine of contributory negligence. Let me just check. Ay, meron pala akong civil code dito. Oh, this is your first subject in commercial law? Oh, yes. Okay. Commercial law is not a difficult subject. It's only long. Yes, you will have nervous breakdown because of the length. Especially when it comes to special commercial laws, very long. And there are... Ang init naman ang kape. I remember in America, there was a case against McDonald's. McDonald's lost millions, hundreds of millions of dollars. May bumili ng kape. Mainit. Natapon sa kanya. Sino ang McDonald's? Yan ang kakatuwa sa American torts and damages. Bumili ng mainit na kape. Naligwak sa kanya. Sino ang McDonald's? Dahil masyado raw mainit. True. Liable ang McDonald's. Kaya doon sa abroad, makikita mong McDonald's caution. Water is hot. So and so degrees. Meron mong kalokohan yan. Assumption of risk yan eh. Bibili ka ba ng, pabili nga ng kape na malamig na malamig. Dito, hindi gaanong enforce yan. Doon, ikaw ay nadulas sa supermarket dahil may balat ng saging, ay labot na ang supermarket. Dito, pupulutin ka lang ng may-ari, papagpagan ka lang, okay na. Sasabihin naman ang nadisgrasya, okay lang po. Okay lang. May isang bata sa Pennsylvania yata, anak ng Vietnamese, sila yung mga refugees, pero yung bata doon ay sinilang, pero yung magulang galing sa Vietnam. Nakita ng tatay, ng nana, na hinulog ng nanay ang hipon na buhay sa kumukulong mantika. Dito sa atin, normal lang yun. Tawag ang bata sa Society for the Prevention of Cruelty to Animals. Sinumbong ang nanay. Dahil cruelty daw yun, buhay pa. Nilagay sa kumukulong mantika. Sa atin yun, sasabihin, Nay, ang sarap, no? Sinumbong ang nanay kasi train sila sa school na magsumbong. Fined ang nanay, $500. Ang kagaguhan mo na siya. Hindi ko na malaman kung anong state ito. Nakita ng isang ama ang kanyang anak na nilalapa ng isang fierce dog, German dog. Ay talagang mamamatay ang bata. Ay ang tatay ay baseball player sa minor league ng Amerika. Hindi yung major league. Bumaba, may hawak na baseball bat. Binat ng binat ang aso, namatay. Nademanda siya for killing the dog. Dinefensahan lang niyang anak, ay napatay yung aso. Ay di, kulong siya. Anong klaseng batas? Kakatwa ang kanilang batas sa ibang states. Kawawa naman. Minsan, yung aking anak ay nasa grade 2 pa lang. Tinitinan kong notebook niya ang assignment niya. Nakalagay doon, hotlines. hotlines, kasamang Society for the Prevention of Cruelty to Animals, kasamang police, fireman, 911, etc. kasama. Nakalagay doon, kung ikaw pinalo ng magulang mo, ito ang tawagan mong telepono. Ginawa ko nga, pinunit ko nga yung page na yun. Meron mo yan, iba ang kultura nisa sa atin. Ngayon, if the plaintiff is negligent, is it possible for a negligent plaintiff to also recover from the defendant? The answer is yes, if his negligence is only contributory. The proximate cause of the injury being the defendant. Ibig sabihin, wini-weigh mo ang kasalanan. Kung may kasalanan ng plaintiff at hindi naman talaga siya ang proximate cause at ang pinakamalaking kasalanan ay nasa defendant, liable pa rin ang defendant. Makaka-recover pa rin ang plaintiff, kaya lang reduced, mitigated. You follow me? Now, this is not a Spanish concept. This is an American concept. In the law firm before, we used to call this contribs. In fact, that was my first assignment as a new member of an American firm, and I was told by my boss, your first assignment, Willard, is contribs. Bagong-bago ako, tanong ako sa isa, what's contribs? Sabi sa akin ng itim na abogado, you don't know what it is? Sabi ko, I don't know. That's why I'm asking you. What's contribs? Sagot sa akin, contributory negligence. Oh, sa tuwa ko, thank you, man. Tawa siya ng tawa. Hindi ko na alam ang contribs. Dahil iba naman ang kanilang term sa atin ay buo. Contributory negligence. Sa kanila, contribs. Minsan magugulo ka sa kanilang term. Yung meaning nila, suntukan, sasabihin pa nila, interpersonal interaction, close range. Close range, interpersonal interaction. Tinanong ko, what does it mean? Fighting. Bakit kailangan mo sabihin yun? Close range, interpersonal interaction. Di ba sa mga kano nauuso yung term, SUV, etc. It came from them. Short-range ballistic missile. Handheld short-range ballistic missile. I was in a detective school and I didn't know what it meant. And I had to ask my seatmate who was a Taiwanese. What does it mean? He talked to me in Chinese. I did not understand. Yung pala, pistol. Pistol. Handheld, short-range, ballistic missile. Wala pistol. So, nagbiro ako. What do you mean by the masculine engine? Walang makahula. Hindi ko nga sinabi. I didn't tell them I meant the male organ. I was just inventing. Okay, but you know, the mother provision of contributory negligence is 2179. That's the mother provision. The children are 1741 and 1762. But there is another provision on contributory negligence, but somewhere on the other side, it's 2214. Could you check it for a while? 2214 also talks about contributory negligence. 2179 is the mother provision. 1741 and 1762 are the provisions in relation to common carriers. Now, there was this case of Estacion versus Barredo or Berado. I don't know kung naabutan nyo pa yung Ford Fiera na sasakyan. May Ford Fiera ng unang panahon. Ginagawa ang passenger jeepney. May isang passenger na ayaw umupo sa loob. Gusto niya nakasabit lang siya. Pinabababa na siya, bumaba kunyari, pero nang umandar, sumabit uli. Tapos, mabilis naman ang takbo nitong driver ng Ford Fiera, nahulog tuloy siya. Can he recover? Yes. Ang kanyang negligence ay contributory lang. Kasi ang cause ay yung talagang mabilis na pagtakbo ng Ford Fiera. Kasi kahit siya ay nakasabit, kung hindi naman mabilis, hindi siya nahulog. That's why contributory negligence, while a defense, is not a full defense. It's only a partial defense. Because the common carrier can still be liable in case it's the common carrier which is the proximate cause of the loss. You know, even if common carriers have liabilities under the law, common carriers are also allowed to have defenses. And the most common defense that the law actually speaks of is the so-called exercise of extraordinary diligence. But it is very difficult to describe the defense of extraordinary diligence. That's why there are more down-to-earth defenses. And one of the defenses, and some of the defenses, especially in relation to destruction of goods, are the ones mentioned in Article 1734. They constitute also defenses of the carriers. And number one there refers to what we normally call in civil law as fortuitous events, isn't it? Flood, storm, earthquake, lightning, or other natural disasters or calamities. Now this is a defense because of Article 1174. That's the mother provision of fortuitous event, blah, blah, blah. Now as a response for those against which cannot be foreseen, or even if though foreseen are inevitable, isn't it? So the general rule is, if you try to summarize the rule on fortuitous event, no person is responsible except SLN. SLN. Hindi yun sumalangit na wala. S, stipulation. L, law. You will take up the details of this in your torts. And N is nature of the obligation requires the assumption of risk. Very easy, isn't it? No one is responsible except SLN, stipulation, law, nature of the obligation requires the assumption of risks. Now, in relation to common carriers, for flood, storm, and natural disasters to be exempting, you've got to comply with the requirements of Article 1739 of the same common carrier provisions. And that will be your guide instead of memorizing a lot of things. Because if you memorize jurisprudence, the requisites are very long and they could be summarized under a simple sentence. That the natural disaster must be the proximate and only cause of the loss. You follow what I am saying? That's how to summarize the rule on exemption from fortuitous event. Let me write this for a while. If you want a fortuitous event to be exempting, the cause of the loss must be fortuitous event only. So, if fortuitous event was accompanied by negligence, the common carrier is liable. Because it is not the only and proximate cause of the loss. If fortuitous event is coupled with bad faith, the common carrier is liable. If fortuitous event is coupled with delay, then the common carrier is liable. If there is fault, then the common carrier is liable. Fortuitous event will not be exempting, because for fortuitous event to be exempting, it must be the only and proximate cause of the loss. That is the shortcut to analysis of fortuitous events. Now, if the loss was caused by thievery and robbery, the thievery and robbery must have been committed with grave or irresistible violence, threat, or force. Using 1745, number 6 in the reverse. In the reverse, baliktarin mo. Yan ang jurisprudence. Yan ang ginamit sa De Guzman versus CA. Yan ang ginamit sa Bascos versus CA. Yan ang ginamit sa FGU Insurance versus, not in FGU. Yan ang ginamit number 1 sa isang kasong Asia Literature. Halimbawa, may pagnanakaw. Kailangan ang pagnanakaw was attended by grave or irresistible threat, violence, or force. Threat, violence, or force. Bibigay tayo ng halimbawa ng bar exams na walang irresistible violence, threat, or force. I'm just trying to recall right now. That's why I'm drinking coffee. It's still scattered in my mind. Maya I will remember them. Okay? Let us suppose I wanted, or a company wanted me to transport sensitive electronic equipment from Manila to Baguio. Why? Why did they select me? Because they know I was awarded the best driver nationally for the past 10 years, consistently and consecutively for the past 10 years. So, I have a van, a big one. I was entrusted to transport 10 million pesos worth of sensitive electronic equipment. Of course, they were confident because I was a national awardee for 10 years. And so, from Quezon City, I proceeded to Baguio City. While I was in the NLEX, suddenly, a storm occurred. And that storm is a kind of storm, a weather disturbance that cannot be detected by existing weather radar or equipment. And it rained so hard, with every drop of rain as big as this. The rain was pouring, everything was dark. But suddenly, there was a slight opening to my right, and I noticed it was only storming and raining actually in the place where I was driving my van. It was following me. That storm is called Now You See It, Now You Don't. An extraordinary weather phenomenon. From 70 kilometers per hour, I slowed down to 15 kilometers per hour. Why? I only had 1 meter visibility from the wheel. And I was craning my neck. 15 kilometers per hour. That's faster than a minor or a normal jogging. Vroom, vroom, vroom. Then it would storm. There would be thunder, there would be lightning, but a localized one. Only 3 times wider and bigger than my van. Then suddenly I hit 2 dark figures. You know what those dark figures are. There were two carabaos romantically linked in the rain. I hit the two carabaos. There was a ditch by the roadside. I fell, and all the electronic equipment were damaged because I turned turtle, and they were all washed away by the rain. I was sued. My defense was fortuitous event. Could I invoke fortuitous event? The answer is no, in most probability, because there was negligence on my part. When I knew that my visibility was only 1 meter, it's only like this, the prudent person should have stopped by the roadside and should have waited for everything to subside. But I persisted on driving. There is a form of negligence. That illustrates that the rule should be the fortuitous event should be the only and proximate cause of the loss. Human intervention already entered the picture because I was not very prudent, I was negligent. That is not a true story. That is only a hypothetical situation. But let me give you a more serious example. Let's talk about the case of Arada versus Court of Appeals. It's 210 scra. 210 scra. Page 624. This was about a ship. The name of the ship was MV Maya. Maya, the little bird, M-A-Y-A. The ship was a small ship. And that may have been the reason why it was called Maya. The small ship. And the ship came from San Carlos City. San Carlos City should be in Negros Island, right? Right? Who are from Negros here? Come on, raise your hands. Ay, sus. Why taga Negros diri? Yeah, Now look. Okay. From San Carlos City to Mandaue City. And Mandaue City is in Cebu Island, is it not? Okay. Lapu-Lapu, Mandaue. Yeah, Cebu City. Okay. Now, you know, while it was midway, a storm occurred. The ship sunk. Because of the storm, it was battered by the waves. It sunk. And so the cargo owners sued the ship. Investigations made by the Marina revealed, number one, that 2/3 of the crew members were unlicensed. Number two, that the ship was not actually seaworthy. And number three, that the ship owner ignored the weather bulletins for the day. Can it now invoke the benefit of a fortuitous event? The answer is no, because there was negligence. There was fault. Fortuitous event is no longer the proximate cause and the only cause of the loss. See, that's how to analyze fortuitous event. It was used once in civil law, but force majeure. It could have been 200 to 2,000 bar, number 12. It's about a lady named Christina who went to a jeweler and said to the jeweler, "Pakiayos naman ang aking alahas. Kailangan ko sa ganitong araw." Ang sabi ng mag-aalahas, "Bumalik ka sa ganitong araw." Pumunta si Christina sa mag-aalahas at sinabing, "I demand for my alahas." Ang sabi ng jeweler, "Hindi ko pa tapos. Bumalik ka na lang after 5 days." After 5 days, bumalik. Anong sabi ng jeweler? "Kami ay narab kagabi. Nilooban kami." Force majeure. Get my point? Can the jeweler invoke force majeure? No. Why? ¿Por qué? There is delay. Very good, children. Impressive. Because the force majeure was not the only and proximate cause of the loss. You go to Fortune Express versus CA. That is 305 scrap. Fortune Express. There used to be this company plying the route from Cagayan de Oro City going to Lanao before. This is a beautiful story. When I was once in Iligan, I asked the students there whether they know about this case. Oh, everybody knew about the case. Because the one who was involved there was a lawyer. He was killed. One of the buses of Fortune Express in a place actually in Misamis Oriental, the boundary of Misamis, and there must be a boundary, Lanao and Misamis. And a jeep filled with people actually was hit and was rammed by a bus of Fortune Express. There were passengers who died. And so the relatives of the victims made representations with the bus company for the payment of damages. The bus company promised to pay. Oh, but it never kept its promise to pay. So the relatives were mad and they issued a warning, let's call it a threat. We are going to burn the buses of Fortune Express. And this was known to the intelligence community. And the management of Fortune Express was actually told about these threats. One day, in the terminal in Cagayan de Oro City, several passengers boarded one of the buses of Fortune Express, and without their knowledge, 3 armed men boarded the bus. And going to Lanao, there was actually a place there where few people were living and there were few houses, and the 3 armed men stopped the bus. And all the passengers were asked to disembark. Then there was a lawyer named Attorney Kaurong. He went back to the bus. He was already out of the bus together with the other passengers. And he went back because he left something on the overhead bin. You know the overhead bin in buses? I was told later, I did not confirm this, but I was told by one of the students there, nililigan, sir, kasi binalikan yung ata si case niya eh, at saka meron mga papeles doon, kasi lawyer siya. Siya yung umakyat, nakita niya na binubuhusan na ng gasolina, yung palang armed men, may dala pang gasolina. Binubuhasan ng gasolina, yung conductor at saka yung driver. Kasi kasamang susunugin sa bus. Si Attorney Kaurong nakipag-usap sa kanila. In other words, the conversation turned into an altercation. And to cut the long story short, 3 shots rang out. Attorney Kaurong was shot. He died. So the heirs of Attorney Kaurong sued Fortune Express. The defense of Fortune Express, grave or irresistible force, violence, or threat. Question: could it invoke 42.7 as a defense? Answer: no. There was negligence. There was negligence because Fortune Express already knew that there were threats against its buses. It did not undertake security measures in its terminals. There was negligence. The plea of force majeure was not recognized by the Supreme Court. Remember our case of the Guzman versus CA, where one truck filled with Liberty-filled milk owned by the Guzman was hijacked by 3 armed men. According to the Supreme Court, hijacking from 3 armed men constituted fortuitous because there was no indication that there was fault on the part of Ernesto Sendanya. There was grave or irresistible violence or threat. Follow me. Could you open that one to your bar exams if you have their 1995 number 14? 1995 number 14. This was an example of a bar exam. There was something mischievous in the bar examiner here was mischievous. I like him. He gave this exam, and this is an example of a bar exams where the bar examiner did not recognize the defense of grave or irresistible, etc., etc. It was not force majeure. Well, the principle is the same. If it is force majeure, it must also be the only approximate cause of the loss, because it's the equivalent of fortuitous event. Although fortuitous event is generally used to mean natural disasters, what they used to call acts of God, we refuse to call it acts of God because God is not a vengeful God. Imagine you drown in a raging river and you say, it was an act of God. What an accusation without due process of law. You didn't even give God due process. See? No. So we use the term natural disasters. Listen to this. M. Dizon Trucking, also called Dizon, entered into a hauling contract with Fairgoods Corporation, whereby the former bound itself to haul the latter's 2,000 sacks of soya bean meal from Manila port area to Calamba, Laguna. Matanda ang bar examiner nito kasi yung English matanda. Listen to this. To carry out faithfully its obligation. Pag bata, hindi maglalagay ng faithfully. Dizon subcontracted with Enrico Reyes the delivery of 400 sacks of the soya bean meal. Aside from the driver, there were 3 male employees of Reyes who rode on the truck with the cargo. 4 silang lalaki. 3 sumakay, pahinante, 1 driver. Investigation by the police disclosed that while the truck was on its way to Laguna, 2 strangers suddenly stopped the truck and hijacked the cargo. Investigation by the police disclosed that one of the hijackers was armed with a bladed weapon. Yung isa armed with a bladed weapon, while the other was unarmed. For failure to deliver the 400 sacks, Fairgoods sued Dizon for damages. Dizon in turn set up the defense of force majeure. Is there force majeure? No. The hijacking in this case cannot be considered force majeure. Only one of the 2 hijackers was armed with a bladed weapon, as against 4 male employees of Reyes, 2 hijackers with only one of them being armed. It cannot be considered force majeure. The hijackers did not act with grave or irresistible threat, violence, or force. The UP Law Center was very, very courteous. It should have added, that was an act of cowardice. See, but it did not add it. See, that is an actual bar exams. 1996, number 14. Remember, we had this morning. AM trucking. Never mind. Let's just recite it. AM trucking. One of its drivers with rice inside the truck stopped by Bulacan to visit his girlfriend. Habang nakikipag-usap siya sa kanyang girlfriend, ninanakaw na pala ang mga bigas sa truck. Ang sabi, force majeure ba? Hindi. Dahil there was no grave or irresistible threat, violence, or force. The taking of the rice was surreptitiously done. There was no grave or irresistible violence or force. Okay? Now, try to think about, there are other bar problems, but I don't want to read them anymore. Let's have one topic here on a defense like force majeure. Mechanical defects. Mechanical defects. Would mechanical defects be considered force majeure? You know, the Supreme Court is very consistent on this score. Like in Necesito versus Paras, for instance. You remember this because this is the first case that is being assigned to you in first year. Necesito versus Paras. Remember that? You try to recall. If you don't, never mind. 104 scrap 75. This was a case involving Philippine rabbit. The bus fell into the river while crossing a small bridge. Why? There was a defect in the steering knuckle. And the steering knuckle was new. It was bought from a manufacturer. Philippine Rabbit inspected always regularly, made a monthly inspection of its equipment. It never detected it because it was a hidden defect inside the buckle, inside the iron, the steel. You could not see it visibly. And so a passenger died, some were injured. And then the defense of Philippine Rabbit was force majeure. It was not their fault. It should be the fault of the manufacturer. You know what the Supreme Court said? The passenger is suing you. If there is a defect in the manufacturing, you are considered the agent of the manufacturer. There is no privity of contract between the passenger and the manufacturer. As far as the passenger is concerned, you are sued. This is not force majeure because this could have been avoided if there was no human error. So, if you are liable to the passenger, then you sue the manufacturer. But as far as the passenger is concerned, there is a privity of contract between you and the passenger. The passenger has no privity with the manufacturer. Beautifully decided case. But it did not explain why it was not force majeure. It was explained on the basis of absence of privity of contract between the passenger and the manufacturer. So to protect the passenger, the carrier will be liable. Let the carrier recover from the manufacturer. Or if it is sued, file a third-party complaint against the manufacturer. But as far as the passenger is concerned, you are liable. The Supreme Court has consistently recognized that mechanical defects are not fortuitous in nature. Like for example in Ubido versus Court of Appeals. This is the very first page of 281 scrap. Ubido versus Court of Appeals. It was also negotiating a road and actually negotiating a small bridge. The front tire blew up. It blew up. It was new. It was only 5 days old. So, Ubido expressed it. The company said, we are not liable. It's the manufacturer. You know what the Supreme Court said? You are liable to the passenger. Recover from the manufacturer, but the passenger will recover from you. So, those of you who are owners or are common carriers here, whose families own, public utilities, think about this. It's very difficult to win a case because of the presumption of negligence. It's even very difficult to invoke force majeure with respect to mechanical defects. Remedy, you get as much insurance as you could get because it's very difficult to win. Our law firm used to be the lawyers of Victory Liner. We would not want to go to the court. We would just talk to the passengers and negotiate because it's a waste of time. You will lose anyway. And the mode of thinking of judges and courts is in favor of the passenger. It's also very difficult to win a case which is much publicized. See? For example, there are many who are sued in relation to the Ampatuan case. And I know many of them are innocent. But it's very difficult to acquit them. Those who are really innocent. Why? Because a judge should never go against public opinion. Very difficult. That's very difficult. See, very difficult. See, you're handling the impeachment case, the defense would never win. Right from the start, you would know the defense would not win. Because all rules of evidence will be thrown out of the window under the doctrine that an impeachment case is the sui generis. In other words, the evidence there would be rules that are considered free for all. The normal winners in publicized cases are those is decide where there is more public sympathy, because the judge becomes a hero and the lawyers become heroes. Very difficult. Lawyers of common carriers, you just negotiate. You just compromise. So who are common carriers here? Persons. Not corporations, persons. No one? Common carriers? Well, I'm a common carrier. I carry my grandchildren on my back for a fee. Okay. Let's talk about baggages. Okay. Baggages. Oh, it's only 3:45. Okay, very. You know, this is a very simple topic in the law on common carriers. There are two kinds of baggages. The baggages that are in the custody of the carrier. Sinorender mo. The rules there would be the normal rules on common carriers from 1733 to 1753. All of them. So extraordinary diligence, correct? Okay. But if it is in the custody of the passenger or the servants of the passenger or the employees of the passenger, you use 1998 of the Civil Code, then 2000 of the Civil Code up to 2003. This concerns the responsibility of hotel keepers, which are applicable in the case. In other words, the baggages brought inside the carrier and is in the custody of the passenger or his employees, when brought inside the carrier and under the custody of the passenger, is considered a necessary deposit. It's considered a necessary deposit. And the carrier will be responsible for those if two conditions are complied with. Number one, the carrier has been notified of its presence. And number two, the passenger has actually complied with the cautionary measures advised by the carrier. If those have been complied with, the carrier will be liable. But the carrier will not be liable without a notice of its presence. So, if you have an attaché case filled with money and you are going to take it up, tell the conductor, please, I have here an attaché case filled with money. Keep watch while I sleep. When you wake up, it's gone. Oh, it's a very simple one. Now, let us have an example. A Victory Liner bus made a stopover in Tarlac because there is a place for the bus to stop. It had a pit stop. You know that place? Yes, beside it is Grand Prix Hotel. That's all right. Then, a robber who was fully armed to the teeth, plus 5 hand grenades, entered the bus, got the luggage of one of the passengers in broad daylight. Because of fear, the luggage was surrendered. It contained diamonds from the collection of Queen Elizabeth of England. Is the carrier liable? The carrier knew of its presence. Is the carrier liable? Of course, no. There was grave or irresistible threat, violence, or force. Force majeure could be invoked. Oh, you get my point? But the conditions of liability as a rule is, the carrier should have been notified. He should have complied with the precautionary measures suggested by the common carrier. Okay. Is maritime commerce a part of your lesson? Huh? Oh yes. Next meeting, if we have time, we will practice some questions, okay? I think we will have, because this is short. But anyway, I still have around 1 hour. I still have 45 minutes with you. Don't smile. You know your smile is naughty. It is full of meaning. I still have 15 minutes. Okay? Now, there is a doctrine in maritime commerce called the doctrine of limited liability. A doctrine called also as a result of the so-called real or hypothecary nature of maritime transactions. I will just tell you a short history of this doctrine of limited liability, okay? Don't you worry, you will go. I know. You're pouting now. I know, I could feel it. The so-called the silent protest. You know, I could feel the in the ions, you know, the ions here, the pressure, asking me, hey, you go out. You know, during the early age of sea exploration, you will notice the ones who actually were very active in sea exploration were the monarchies of Europe. Portugal and Spain were the leaders at the time. Then later on, after a century, emerged the greatest country with respect to naval forces, then Great Britain, okay? Then later on, the United States. Especially when the United States won in the Battle of Manila Bay on May 1st, 1898, wiping out the entire Spanish Armada of General Admiral Montojo, remember that? And who was the leader of the American fleet? Commodore George Dewey, is it not? Yes, May 1st, 1898, the Battle of Manila Bay. Now, the monarchies of England wanted to encourage private people to engage in sea exploration. But the trouble is, they were hesitant because of the risks involved. And they found themselves still being sued for damages despite an unsuccessful sea exploration. So the monarchies invented a rule, don't you worry, if your ship is lost, you have no more liabilities whatsoever. Even if all the men died, you will not be liable anymore. So the doctrine of limited liability was formulated in order to encourage exploration of the seas. In fact, there was even a prevailing belief at that time which induced fear in the minds of explorers because they believed the world was flat. You reach the end, you will just fall down. But Magellan and Christopher Columbus were able to prove that there was no such thing, that the world was round. When you sail from the east to the west, you can go back to the east because the world was round, it was not flat. And so England and Portugal divided the world into two parts, the east and the west. The east to Portugal and the west to Spain. Remember the Treaty of Tordesillas in the 1500s? Oh yeah, remember your history. It will not be asked in the court. So the doctrine is no ship, no liability. No liability if the ship sinks. But because of changes from generation to generation and until the rule trickled down to us through the Code of Commerce. We now have exceptions to the rule, no ship, no liability. For instance, if you meet a bar question, if the problem only in the bar tells you that the fault was purely of the captain, the ship owner can still invoke the doctrine of limited liability. But if it appears from the bar problem that the ship owner was at fault, or the captain and the ship owner were at fault, there was concurring liability, then the ship owner cannot invoke the doctrine of limited liability. And that is very consistent in your bar exams. Next meeting, we're going to read you samples. Okay? So, if the ship is not seaworthy, that is the fault of the ship owner. If it sinks, the doctrine of liability, limited liability, cannot be invoked. If it is the fault of the ship captain together with the ship owner cannot invoke the doctrine of limited liability because there is presence of fault on the part of the ship owner. You get me? Now, there is another reason when you do not use the doctrine of limited liability. And that when the voyage is maritime, is not maritime. The voyage must be maritime. For the first time, it appeared in the 1985 bar exams. When the voyage is not maritime, do not apply the doctrine of limited liability. Because the doctrine of limited liability applies only when the voyage is maritime. Sidel, sweetheart, come on, baby. Okay, thank you. Now, what did I say? Okay. Now, another situation. When the carrier is not a common carrier under the particular situation, you do not apply the doctrine of limited liability. Why? If it is a private carrier, you don't apply it. Because this presupposes that the carrier is acting as a common carrier. Remember, we are talking about common carriers. When the liability of the ship owner is liability for the expenses of the last repair of the vessel prior to its loss, the ship owner must pay the expenses for the last repairs. Next, when the liability is based on the workmen's compensation law, the ship owner will be liable. It cannot invoke the doctrine of limited liability. Next, when the vessel is insured, there must be payment because it is insured. The doctrine of limited liability cannot apply. When the voyage is a river voyage, it's not maritime. Okay? River is not maritime. What voyage is it? Riparian voyage. It's not maritime. Or, you don't want to use riparian? River voyage. So we will discuss this together with bar examples next meeting. Would it be alright for us to say, let's say goodbye temporarily and let's meet again on Thursday at 5 o'clock in the evening? Yes, you are so animated. Okay, thank you very much for coming. Bye-bye.